So I'm going to say this. It didn't even take 6 months, 12 months, 18 months, 24 months for us to find out what we just found out in the last 24 hours. And for everybody that has been supporting the videos in the last 48 hours, I said thank you. I thank you for the likes. I thank you for the comments. I just thank you. I thank you for sharing the video. I thank you for being here. And we're going to go ahead and talk about this. Now, I woke up this morning to somebody calling me. Hey, Tony Talks, guess what? You're not going to believe this. You're not going to believe this. So I started. They sent me the video with freezing. Oh, somebody else done got the files. I said, okay. I said, I got to go find the files. I found the files. Now, I know that everybody is starting from the top, but you know, I'm going to start from the bottom and work my way up. Now, I have randomly selected, I just said, I'm going to get this one. I'm going to get this one. I'm telling you what I did. And we're going to see how this thing plays out. Because hey, you can start at the top, but I'm thinking there is the actual document itself, and everything is exhibits. And guess what? That's where I'm going to live at tonight. So I got I got 1, 2, probably about 6 or 7 paragraphs, randomly selected paragraphs throughout the whole entire docket, right? But I'm going to share my screen and we're going to go over some of the exhibits because I want to see. You mean to tell me, listen now, you mean to tell me their legal team had about 130 pages of exhibits to support the appeal? Say what again, Tony? I said, you mean to tell me that his new legal team in 193 pages, 130 pages is nothing but exhibits? That is the supporting documents that when that new regional judge read this thing, yeah, of course, he's going to read the whole entire documents, but the proof is in the exhibits, the supporting documents, the supporting emails, the supporting pictures. Now, that's how you build your packet. Now, what? Also, on what I saw with No Captivity with Freezy, her name is Thelma Anderson. Now I got a name. I think Freezy asked her, he said, hey, based off how this appeal is written, he said, do you think that this appeal packet, is it something that, you know, they kind of glazed over, or is it something that they might into? She said, oh, no. She said, oh, no, they actually put it down in this packet. So that's why I said, since everybody's going from the top, I don't want to bring you the same content. As you know over here, you're not going to get the same content. And guess what? Let's go ahead and start, but let me go ahead and show some love in the comment. Let me see who came over here early. The Tony Talks vested up, compelling sports edge. Free Karmelo, free Karmelo, free Karmelo, free Karmelo. The power of God. The power of God. You mean to tell me, y'all, I don't know if I'm going to be able to keep my excitement down. You mean to tell me that God has heard his people from on high and we getting this information in 30 days? Now, when have you ever heard a case of this magnitude? We're getting everything within 30 days. Man, y'all better go ahead and give God some praise over here. If you over here, Tony Talks vested up, because you know we talk about God, faith in football, and now we're talking about God, faith, and this judicial system, because something got to stop. It got to stop. They're killing our kids. They're killing our brothers, our sisters, our mothers, our fathers. For what? For being wrapped in melanin? Is that what it is? Call his name. Call his name. We got God's attention, y'all. Come on. This is when you grab onto the power of Almighty and you start praying and seeking his face so he can open up the doors for all of us. This is the time. This is the time. This is a spiritual awakening and a reckoning. And they don't even know that it's here. They don't know that it's here. And guess what? If they don't know that it's here, it is not my job to open their eyes. It is not my job to knock on their heart. It is not my job to open their ears. I'm talking to the people. I'm talking to the people that God has called over here to this channel. It doesn't matter what's going on any time of the day. You are here with me, and I'm not going to waste your time, but we're going to go ahead and give God the praise in here. Let's go. Come on with it. Come on with it. Come on with it. Oh, I'm getting a hot flash right now. Hey, how you doing, Justine? Justine, shalom, blessed and beautiful family. Hello, Tony. Hey, what's up, Cindy Carr? Hey, how you doing, Indy Mouse? Hello, Tony. You turning me into a Vesta. Let's go. Come on with it. Come on with it. Come on with it. Hello, I'm new here. What's up, Virgo Princess? Welcome to Tony Talks Vested Up. And in the meantime, go ahead and get your notes, your drink, and your vest, because we stay vested up over here at Tony Talks Vested Up, compelling sports edge. We'll tell you about that later. Well, welcome to the room. Welcome to the room. Y'all, welcome to the new Vestas to the room. What's up, SDP 1208? What? I need to talk to you. Hello. Hey, how you doing, Lady E? Hey, Slim. Are you having technical issues? My audio is glitching. Is my audio glitching? Is my audio glitching? I don't think so. Let me know if my audio is still glitching. I don't think so, but I'm pretty sure that praise got through. I'm pretty sure that praise got through. Welcome to the Tony Talks Vested Up Compelling. Yes. Hell, evening, everyone. I was watching my boy Ticket TV. He cooking over there. When y'all get some, go check him out. He's on the case too, and he has some very interesting info. Now, 420, make sure you tell them when over there, you tell them to come to Tony Talks Vested Up Compelling Sports. Also, tell them to come over here. I got a different perspective for them. Free Karmelo, free Karmelo, free Karmelo. Bring our family home. They go, let my people go, Pharaoh and his army. Amen. Tony Talks, I agree. God is moving in the atmosphere. Karmelo is coming home. The Most High, Abba Yah. Don't play about his chosen people, aka the apple of his eye. Come on with it. Come on with it. Okay, I'm good. Okay. Hey, how you doing, Bunny? Bright evening, Miss Tony. Hey, how you doing, Destin? How you doing? How you doing? Hallelujah, praise Yah. Hallelujah, praise Yah. I got the right people in the room. I got the right people in the room, and I'm not going to hold you. I'm not going to hold you. I'm not going to hold you. Now, let me see. Here we go. Now, like I said in the beginning, if you're just coming in, I randomly selected some sections from the whole entire packet. Everybody is starting from the top. I'm going to start from the middle, the bottom, and we're going to hit some exhibits because I want to know exactly what's going on. Now, once again, thank you to this beautiful, well-assembled team, pro bono. I'm pretty sure somebody is going to take care of them in the background, but pro bono. Thank you again, awesome legal team. Come on with it. Shout out to the legal team. Shout out to the legal team. Hold on. I do not like that little thing right here. I do not like this little thing here. But please go ahead and like the button. Please go ahead and hit the like button. There we go. I got that thing off. Now, here we go. Let's go back to the comments. Okay, gotcha. Now, here we go. Now, we already talked about this. This is just a small recap, very small recap. You know, in the beginning, this is when, this is about Texas. I want to bring this up about Texas. Once again, if you don't know, Texas, out of all the states in the United States, it has, how can I say it, the highest exoneration rate across the nation. As you see, since 1989, Texas has over 450 exonerations. And 2 years ago, it recorded 26 exonerations, the highest in the year, the highest in the nation. And you might as well say, and we need to go ahead and contact the National Registry of Exonerations and tell them to go ahead and add one more to Texas record, because Karmelo Anthony will get exonerated based on what we saw in this packet. If this retrial, when this retrial is scheduled and granted, it's going to be one more exonerations on the books. Let's keep going. I just wanted to go ahead and show you how we do it over here at Tony Talks Vested Up. You already know we went through this. You already know. Oh, listen. For all, I want to bring this up. Extreme prejudice. There is two different types of prejudice in a court of law. It's called accurate prejudice, meaning the jurors, the voir shows jurors cannot be impartial because of preconceived opinions, right? But the Karmelo Anthony case is extreme prejudice. Is much rare. It applies when publicity and community sentiments is so inflammatory and pervasive that the courts conclude a fair trial is essential, impossible without proving each juror is biased. This is that Karmelo Anthony case. And based off some of the information that I read, I only had about 2 hours to actually look at the documents. This fits the case. Let's keep going. Let's keep going. You already know, we already been talking about the triangulation. We already did this. Here we go. Here we go. But I do want to go ahead and put a stamp on it. I want to go ahead and put a stamp on it. What you say? That's right, Tony. Share and support other podcasts that are giving practical, sensible intelligence in their content creators like yours. Facts. Hey, please share my name too. Please share my name too. Please share my name. Now, here we go. Now, this is the information. Let's walk this thing down. This was filed 2 days ago, 48 hours ago, on the 7th of July at 11:41 in the morning. You all see the information. You see the cause number. You see the state of Texas versus Karmelo Anthony. You see that information here. And you may have already heard this information. So I just read this page right here. To the honorable judge of said court, come now, Karmelo, defendant Karmelo Sincere Anthony, by and through the unsigned counsel and pursuant to Rule 21.1 through 21.9 of the Texas Rules of Appellate Procedures, move the court to set aside the judgment of convictions and sentence and grant a new trial. I like that. Make it clear. The defendant moves for a new trial on 4 grounds. First, the court committed structural error when it materially restricted public access. Well, Tony Talks vested up. What you talking about? What you talking about? That's the 6th Amendment, y'all. You remember when I was breaking down the different amendments? That was the different amendments, okay? Here we go. Let's see here. Let me slowly get this out of here. First, the court committed structural error when it materially restricted public access in violations of the right to the public trial. Second, the state's repudiation of parties' unrecorded agreement and the defendant relied on it coerced the waiver of Mr. Anthony's right to testify and deny him. I cut that off. I'll be back tomorrow with that one. Let's see here. Let's go to the next one. Like I said, now this is paragraph number 79. Let me blow this up right here. The judge on statement, like I said, this was random. The judge on statements of his purpose confirms that the closure was deliberate denial of the, you see that word, public access the Constitution guarantees. In a written statement to News Fox after the trial, the judge explains, I understood the public's desire to know what happened in the courtroom. The overwhelming focus of my ruling regards the media in the courtroom was to protect the process, witnesses, and jury. Look, we already discussed that last night. We already know how Judge John Roach, he put the witnesses at a top priority than Karmelo Anthony, who was the defendant in the courtroom. Now that the trial is over, it is important to me to provide transparency. This is a mission that public access was restricted during the trial, and that transparency was withheld until the trial was over. We're going to go to Exhibit 5. We're going to see what Exhibit 5 is, okay? But the public trial guaranteed secured the public's right to observe the proceedings as it happened. It is contemporaneous openness to the trial, not a retrospective account offered after the verdict and the sentence. So what is he saying? So what is his legal team saying? Well, when a person says they want a speedy trial, a public trial, it's not after the fact. We're supposed to see exactly what's going on during the trial, during the actual process, proceedings of the trial. You're not going to give us something after the fact. No. That's a violation of the Constitution, 6th Amendment, okay? Here we go. That the verdict in the sentence that assures the proceeding is conducted fairly and discourage misconduct. So that's why people, they definitely like to request a public trial so that the public knows what's going on and there's nothing skullduggery going on behind the scenes behind those walls and nobody's aware of it, such as this case. Now we got proof that this case, so much corruption was going on behind those walls, which is why he didn't want the cameras in there, okay? Let's keep going. Presley, 558 US at 215. Walter, 467 US at 46. Transparency furnished after the trial has ended is no substitute for an open trial and cannot cure the denial of access while the proceeding was underway. The interests of the judge invoked it, protecting the process, witness, and jury are moreover precisely the kind of generic non-concerns that cannot justify closed absence of specific findings on the record, right? Let's go to the next one. Let's see what other random findings did I come up with. Let's see here. Free Karmelo until his back was, oh gosh, come on with it. Karmelo is free. Come on with it. Free Karmelo until his back was. Free Karmelo, hey, Tony Investor. What's up, Simone? Look, listen, Judge Roach, you not fooling us. You're trying to save your ass. Now your retirement and then some. So you remember last night, gosh, I didn't know all of this was in there. Actually, I didn't know where the legal doc talk had got the documents from, but I knew that it had to be out there. So when I was watching Freezy this morning, getting ready for work, I said, it was that bad. Y'all already know about the gentleman's agreement or whatever, but let's see what 99 says. Now, this is my first time reading this, so I'm reading this along with you. And there's some legal terms in here. We just got to get through it together, okay? Number 9, the July 28th order finding failed to, The July 28th order finding failed that test on its face. The July the 28th order findings failed that test on its face. A finding that media coverage has the potential to cause imminent and irreparable harm is a finding of possibility, not imminence. The speculation Davenport forbids. No evidence is recited, none was heard, and the finding that change of venue, jury screening, and the questions would be inadequate alone conceals the point that decides the issue. The alternatives exist, and the court knew them by name. Indeed, it went on to employ 2 of them, screening the veneers through written questionnaires and sequestering the seated jury. That later widely reported and to be confirmed at the hearing, Exhibit 18. So we got to go to Exhibit 18 and Exhibit 5. A restraint is not the least restrictive means where the court owns order camouflage the lesser twos and the court's own trials deploy them. That the order issue, that's a legal term, on no party's motion with no evidence offered by anyone completes the failure. And in the 10 months it operated, not a single violation was ever alleged. Cat darn it. Okay, I got to go back to 100. I got to find 100. Hold on. Let me go find 100 because that started getting too good. Hold on. I want to find 100. Let me go ahead and find paragraph 100. That was getting too good. Hold on. Let me go ahead and open this right here. That was getting too good. I need to go ahead and read 100. Let's see what paragraph 100 is. Okay, let me see if it comes up. Okay. Here we go. 100. Let's see what 100 says. Okay, you got it on your, okay. So far as the record reflects, the imminent harm was never threatened to materialize, and the post-speech remedies Texas law prefer were never needed. The absence of enforcement is not the absence of injury. A prior restraint does, it works through obedience. And here it was obeyed. The order's fourth prohibition serves the restraint from its only asserted justification. The finding speaks of the jury impartiality. Uh-oh. Do y'all remember when I went over jury misconduct? Did y'all remember when I went over juror misconduct? Hold on. The prohibition reaches any statement likely to influence public opinion. Public opinion, generally, jurors or no juror, for nearly a year. Any public medium, a witness who professed the defendant's innocent to a reporter, a family member spokesman who questioned the prosecution, a court-appointed official who described the access restrictions themselves, each spoke of pain of complaint. Did they say there was a witness who professed the defendant's innocent to a reporter? Hold on. Let's keep reading. Whatever latitude Gentile versus State Bar of Nevada 501 US 1030 1075 1991 affords the regulating attorney speech under a substantial likelihood of material and prejudice. We just brought up prejudice, y'all. We just brought up prejudice. Standard that latitude has no application to lay witnesses and spokesperson, and no standard known to Texas or federal law prohibits gagging commentary addressing to public opinion such as. And the restraint interlock with the rest of the design. The gag order solely safe harbors recommendations, hearings, schedulings, court filings, propose a public docket. The court then seals the filing by oral order so that the safe harbor describes the document no member of the public could read. Oh my gosh. Really? Hold on. The gag order itself, meanwhile, provided that it yields only to further written order of the court. Both restraints, moreover, issue sua sponte. No party asked the participants. Hold on. No party asked the court to silence the participants, and no party asked it to restrict the courtroom. The gag silenced those with knowledge. What? Hold on. The access order excluded those who sought it. The sealing erased the paper trail. The sealing erased the paper trail, and each measure recited the defendant's fair trial rights, while the defendant's actual trial was conducted beyond meaningful public view. Okay. The July 2025 order matters to the Waller analysis for the further reason as well. It proves that the court knew that less restrictive toolkit, listening venue change, jury screening, and discretion by name 10 months before the trial. And when the time came to restrict the courtroom itself, the court considered no alternative at all. Well, who was talking? A violation of the right to the public trial is structured error that is not subject to harmless error analysis. We talked about that. Johnson versus US, you see the case, Lilly 365 SW 3rd at 328. Because the closure pervaded every stage of the proceeding at which the order applied, jury selection, the guilty, innocent phase, and the punishment phase, we talked about that, rather than a discrete Achilles hearing, the appropriate remedy is a complete new trial. The structure area reserved any prejudice. Okay, got it. Okay, let's go. Stop sharing. Now let's go to the next paragraph. What paragraph is this? Let's see here. Okay. All right. Let's go to the next one. Let's see what else is in this document. Where we at? Okay, let me go back one page. Here we go. Paragraph 110. 110. In summary, random selected. In summary, the grounds in fact supporting a new trial on the first grounds are the trial court materially restricted public access during the testimonial phase and punishment proceedings. Okay. I thought the mad calf had friends in there. Okay, repeatedly excluding members of the public without the findings or consideration of alternate Waller requirements, such as an overflow room. The same access regime applied across jury selection, guilty, innocent, and punishment, and it repeatedly excluded members of the public from substantial portions of the proceedings, which is true. The resulting violation is structure. The defendant had no earlier opportunity to object, and a new trial is the only adequate remedy. Should the court not find the first ground persuasive, it should consider the second grounds for a new trial. Let's go to the second ground. Hold on. Let's go to the second ground. The second ground for a new trial, the state okay, let me go to pull this one up. Let me go back and share my window. Hold on. Hold on. Whoa. Let's go ahead. Let me share my screen again. What page was that? That was after 100. Hold on. That seemed like it was about to get good. Let's see here. So let's go to 111. The agreement and the finished reliance. Okay, y'all got it up. Blow this up a little bit. Santobello does not involve an identical proceeding settings, but it applies the governing due process principle. When the state induces detrimental reliance on a definite promise, y'all, we heard about this promise. I got to find out what this promise was. And then it repudiates after the reliance can no longer be unfound, fundamental fairness is implicated. In Santobello versus New York, the state made a promise the defendant relied upon and then broke it. Through a change of prosecutors and perhaps inadvertently, the court held that the breach could not stand and vacate the judgment, even though the breach may have been unintentional, and even though the sentencing judge said a broken promise had not influenced him. I got to find the promise. The defense here relied on the parties' understanding through three successive phases of the trials. The voir dire, that's the jury, the opening statement, and the cross-examination of the state witness. And the state's repudiated is only when the defense reached its own case at a point when the reliance could no longer be undone. If the inadvertent breach in the Santobello requires relief, a deliberate mid-trial reputation here warrants at least the hearing the grounds requested. Okay, hold on. Before and during the trial, this is paragraph 112. Before and during the trial, the state and the defense operated under an unwritten understanding that certain character and extraneous offense evidence would be excluded and would not be offered at the trial. Y'all go ahead and remember 112. In reliance on that understanding, the defense made strategic commitments. The defense made strategic commitments that it would later redact. It conducted the jury and the selection of the jury, delivered its opening statement and cross-examinations the state witness, including foregoing questioning it would otherwise have pursued concerning the knife, on the assumption that the agreed upon evidence would not be What? Who said on the defense that the knife would not be introduced, y'all? Hold on, 112. So this is why the knife was not brought to the courtroom. Exhibit 10. Hold on, we finna go to Exhibit 10. We finna go to Exhibit 10. Hold on. So you mean to tell me that the state and the defense operated under a written understanding that certain characters and extraneous offense evidence would be excluded and would not be offered to the trial go down, including foregoing questioning it would otherwise have pursued concerning of the night, on the assumption that agreed upon evidence would not be introduced. The understanding was never reduced to writing a place in record. Affidavit of trial counsel, Exhibit 10. We finna go on this. We finna go on this. Hold on. Let me. To all the racist paperwork is facts. We got somebody here already. Why is the certificate of the appeal document drawn like that? Hey, did you see my answer in the comment under the video? Drawn up on 7-4, likely they knew a guilty verdict was guaranteed because the jury found Karmelo guilty. Are you trying to say June the 4th and June the 9th? Because they found them guilty on June the 9th. I think I contacted you in the comments. I asked you, did you mean June instead of 7? But let's go ahead and go to Exhibit 10. Oh, hold on. I got another one. What you say, Cindy? The truth of the matter is out now. Bring Melo home. Nothing but evil in those people. Come on with it. Judge Couch wrote, it's funny. He said, if you want to get inside the courtroom to view the trial, they should have got up early. Some people was getting up at like 3 and 4 and 5 in the morning for only 27 seats. This is diabolical. Hey, how you doing? Hey, what's going on? How you doing? Listen, go ahead and get your no-show drink in your vest because we finna dive in deeper. Hold on. Now let's go down to Exhibit 10. Let's go down to Exhibit 10. I want to know what Exhibit 10 was. Exhibit 10. Exhibit 10. is Exhibit 10. Okay, 18. Let's go find Exhibit 10. Let's go find Exhibit 10. Let's see what they are supporting or showing evidence in Exhibit 10. Let's keep scrolling. Let's keep scrolling. Here we go. Here go 10. Here go 10. Y'all can see that? Let's see here. This is Exhibit 11. Here goes Exhibit 10. Okay, we got, okay. This many pages in Exhibit 10. Okay, let's keep going. Well, let's keep going. Let's keep going. Then who wrote Exhibit 10? Who wrote Exhibit 10? Oh, the Exhibit 10 is Mike Howard's effort on David. Let's see what he talked about. Signed and notarized. I didn't know this. Hey, Justine, 34 minutes, Exhibit 10, Mike Howard's affidavit. Exhibit 10, Mike Howard's affidavit. Let's go ahead. Go ahead and get your notes and your drink and your vest. Let's see what he wrote up. Oh, this about to get nasty. This about to get nasty. Let's see here. That's the same cause number. Got it. Karmelo Sincere Anthony, the defendant, the state of Texas, county of Dallas. Y'all just bear with me with some of these legal terms, okay? Before me, the undersigned notary public on this day personally appealed Mike Howard, who being by me duly swear, deposed and stated the following. I, Mike Howard, at least 18 years old, of a sound mind, and I am competent and qualified to make this affidavit. I have personal knowledge of the facts stated within, that they are true and correct. Here we go. He said, I declare I was the trial counsel supported by second chair co-counsel Toby Shook, third chair co-counsel Tasha Gooper, never heard her name before, and a briefing appellant co-counsel Michael Mowley, who represented Karmelo Anthony in cause number, you see that cause number, leading up to June 1st. Oh, we're going to get some information. Trial of this case, the defense and prosecution reached an agreement where the prosecution and the defense jointly agreed not to raise any alleged character, reputation, and extraneous offenses, bad acts, evidence relating to Mr. Anthony, as well as Austin Metcalf and Hunter Metcalf during the trial. Okay, we heard that, I think it was last week or this weekend here, that it was the judge had decided not to He told everything. He told everything. Okay, hold on. A document was drawn up for an appeal on forgery, like they knew the verdict would be guilty. Already fixed. Of last year? We got to talk, buddy. We got to talk. Hold on. Let me go ahead and have these comments scroll up. Because you probably seen other documents than me. But I know, come on. Here we go. Okay. Okay, we're going to paragraph number 3. We're going to paragraph number 3. Oh, you say he told everybody? Okay. The lead prosecution in the case was Bria Whiskey. I thought it was Greg Willis. Bill Whiskey brought up the possibility of the agreement of times well before the agreement was discussed in detail and eventually reached. When mentioning a proposed agreement, Mr. Wilski proposed that we try the case clean, which he defines as basically only on what happened under the tent of the day. Under the Memorial High School tent at Kuyakendo Stadium on April the 2nd, 2025, and not go into character, reputation, or extraneous offense and or bad act evidence applicable to either Austin, Hunter Metcalf, or Karmelo Anthony. Okay. On May the 5th, 2026, Mr. Shook and Mr. Wilkie discussed this proposed agreement by phone. During that phone call, Mr. Shook, Mr. Wilkie discussed the evidence of character, reputation, and extraneous offensive bad conduct as it applies to both Metcalf twins and Karmelo Anthony. Mr. Wilkie reiterated that he would be happy to try this without getting into character at all, just on what happened on the day of the track meet. On May, did he keep a diary? Did he keep a diary? Mike Howard kept a diary. Hold on. Mike Howard kept a diary. On May 8th, 2026, the defense and the prosecution team met in the Collins County grand jury room. Is this the meeting? And this was this year. So on May the 8th, 2026, let me keep reading. The prosecution team gave us a document entitled State Notice of Intent to Use Extraneous Offenses, State Notice, and we gave to them a document entitled Anthony's Motion in Lyman regarding the admissible or pertinent character traits evidence under the ambiguous aggressor rule, and evidence under Texas Code Criminal Prod Art 3836. I got to look that up. Here in after defense notice, after tendering to each other respective extras followed a briefing, we then discussed the proposed agreement where Mr. Whiskey referred to a gentleman's agreement. Oh, this is the gentleman's agreement. Okay. Mr. Wilkie outlined the proposed agreement as follows, y'all. So this is Exhibit 10, paragraph 5. Exhibit 10, paragraph 5. Mr. Wilkie outlined the proposed agreement as follows. Both sides try the case without character, reputation, and extraneous evidence for either the Metcalf twins or Karmelo Anthony, and just try the case based on what happened in 10, and doing another description during that meeting, what happened on the day of the incidents. Seeking clarification, I asked, and Mr. Whiskey confirmed that this would mean that the defense would not go into evidence relating to the Metcalf twins, reputation, offenses, extra offenses related to. I know what that means. That they already know who these twins were. So when we said that they were bullies, and it's rumored that they were bullies, we don't have to say that no more. Because why would they put this in a legal document not to talk about the twins' bullying actions and disciplinary actions, discipline actions, right? That means that we don't have to say alleged anymore. They was definitely bullies. Exhibit 10, paragraph 5. Okay. inclusiveness of discipline and write-ups. The Metcalf twins schools record within this framework, as well as racism. In exchange, the prosecution wouldn't. Whoa. You mean to tell me that the twins, they was racist just like their father? We don't have to say alleged no more. It's in the appeal packet. And Mr. Mike Howard is basically saying with his chest, this is the discussion on May the 8th, 2026. You mean to tell me that the twins was racist? Just like their father. Y'all, we got proof. Hold on. In exchange, the prosecution would not go into character, reputation, extra offenses act, evidence relating to Karmelo Anthony. We already know he don't have no issues. We don't know he don't have no issues. Let's see here. At this meeting, I'm here. I saw clarification on how this agreement would work practically, and how to handle the possibility of opening the door to the evidence from either side. During this meeting, Mr. Wiki repeatedly expressed his concerns that the defense would kick open its own doors by asking questions of the witnesses that would devolve into issues restricting from this agreement. So what did he basically say? I know exactly what he's saying. Even though they got agreement, he is afraid that Mike Howard, once that witness got on the stand, Mike Howard, and I've seen lawyers do this, they can ask a question a certain way that would and the witness would answer that question in a certain way where it can lead into a topic that the prosecution didn't want to take place in this. So he's saying he was fearful of this, right? Okay, hold on. Okay, I asked about specific statements made by witnesses interviewed by the police and captured by video on the day of the incident, where those witnesses discussed the Metcalf twins being passionate, triggered, and tolerating not being disrespected, etc., etc. You mean to tell me when we saw the twins walking through that gate and we said that they was hostile and aggressive, you mean to tell me some witnesses said the same thing about the twins? Gotcha. Let's see here. Mr. Wilkie eventually agreed that questions narrowly tailored to ask about specific statements witnesses made to the police. So hold on. I didn't see none of that in the arrest record unless it was on page 2. And that's the only page that I didn't have was page 2. Because in page 1, 3, 4, 5, 6, and 7, I didn't see this. Huh. Okay, let's go. Made to the police about the incident under the tent on April the 2nd, 2025, including statements just described about the mindset and actions of the parties involved in the incident, would not constitute kicking open your own door and thus would not violate the proposed agreement. First of all, who makes agreements like this behind the scenes? Is this something real? I think this is illegal. During the meeting, we discussed terms of the agreement, being that testimony from eyewitnesses under the memorial tent on April the 2nd, 2025, and who were discussing the facts of what happened under the memorial tent on April the 2nd, 2025 would be permissible, and that neither sides would go into character but either Metcalf twins or Karmelo Anthony. During this meeting, I also asked about the agreement regarding the possibility of the defense calling experts. Hey, y'all, we finna get in why Mike Howard did not call not one expert. Hold your vest. I don't know what's about to be said, so hold your vest. Let's see here. The prosecutors only discussed how the agreement would apply to the defense. Hold on. First of all, you mean to tell me the Anthonys have paid Mike Howard, but the prosecutors is able to determine how Mike Howard could use his legal ability to call in experts? You might as well say this was not even, based off this was not a fair trial. This is what I'm trying to say. And for the prosecution to do whatever they want to do on their side, who gave them the right and the authority to determine what the defense could happen, y'all? Nobody considered Karmelo Anthony fate or his fairness to a fair and impartial trial. Nobody considered Karmelo Anthony, the young black boy who's sitting over there, who was locked up, who was bullied in the stands and was defending himself. Y'all, do y'all see anything about self-defense so far in this case? They are worried about character witness and reputations. What? Let's keep reading. Don't let me get ahead of myself. Now I'm getting hot. The prosecution only discussed how the agreement would apply to the defense experts during the sentence phase. So I asked how the probability of defense calling experts, why would he even entertain this? You a defense lawyer. Why would you even entertain such an agreement? So I asked how the possibility of the defense calling experts to testify during the guilt innocent phase would impact the proposed agreement. The prosecutor teams realized that they have not considered calling us The prosecutor team replied that they had not considered us calling experts to testify. What? The prosecutor team replied that they had not even considered Karmelo Anthony defense team calling experts to testify during the guilt or innocent phase. They stated that if the defense called expert witness to testify regarding Mr. Epstein, are you serious? They stated that if the defense called experts to testify regarding Mr. Anthony's epilepsy, y'all, that's medical, on or about the flight or fight response, they considered expert testimony like that to violate the agreement and thus open the door to character, reputation, and extra offense act as evidence. Oh my gosh. Are you serious? Are you serious? That's why it was not discussed about his medical. Hold on, let me go radio style. Hold on. Oh my gosh. Oh my gosh. Whew. Okay. Hold on. Let me take a break. Hold on. Let me go back up here. Educators, Tony, to me, they can't understand what are you teaching. To me, they can't understand what you teaching. Hey, I'm just reading. Tony, Mike Ho gave Karmelo that document designed to be filed and appeal right after the verdict. And sentencing my point, it was just a formality. Mike Ho did and saw the appeal document. Okay. I'm about to, okay. In short, Judge Roach shaped and molded the trial in the direction that he wished for it to go by orchestrating the intentional leaving out the defense entail that he would. There you go, Tesla said. Yes, there you go. Oh my gosh. That means, look, forget about appeal bond. When the next regional judge sees this, Karmelo Anthony, wherever he is, that judge need to do this right here. Hey, yes, this is Judge such and such. I want to talk to the warden of where he at? Wallace unit. Yes, as of now, I want you to, Karmelo Anthony is free. We'll talk about that later. Release that young man now. We, you know what? I'm holding Collins County Judge Roach in contempt of court, and I want him at my office tomorrow morning at 9 o'clock, and make sure he bring his own defense attorney. Do y'all see this? No wonder the case was one-sided. God, hold on. Bullies and racists. Exactly. Oh gosh, open the door. Come on. That's why they were kicked out. Even their coaches told this. And another thing, Karmelo has epilepsy. I just read that. And when he got attacked, he probably feel that. See, you said this about 7 minutes ago, and now we're just getting to that the prosecution didn't want. The agreement was not to have any experts called in, not even to talk about Karmelo Anthony epilepsy. I wonder, did the Anthony family, I know they didn't know about this. And when he got attacked, he probably feel it's right here. It's right here, 420, right on time. Right on time. It's right here on the seconds. Oh my gosh. The tent school right next to Memorial Tent was cut out of the video because they was able to see the whole fight altercation and could. That's right. It's illegal. Come on. The entire case was dirty from the beginning. Where are the haters now? Where are the haters now? Where's everybody that has been harassing us for almost 30 days in our own live stream videos? Where are the haters now? Where are the haters now? Ooh, Judge Roach is the reason Karmelo didn't do it. Money, hey, sure wasn't a fair trial. Misconduct in the, come on with it, justice system. Come on, pray for soul. Come on. The defense lawyer was in on it because he agreed to this. I need to see. You're right. Mike Howard is not totally. Let me just go ahead and get through this. I listen. We may just stop at exhibit 10. I got to see what's in 8 and 18, and then we're gonna call it a night because I need to get my mind right on this right here. Who agreed to this? Hold on. So we know who all gathered those 8 months at the round table, conjuring up Karmelo's fate and sentencing. That's why it went so fast. Facts. They already knew. Like the other investor said, Coach Judge Roach, he orchestrated this into the direction that he wanted to go. You're right. The fix was already in. So now when people say that we said that the fix was in and they called us crazy, where are all the crazy people that said that we're over here talking crazy? And remember, somebody said, why are you not talking facts? This is facts. Mike Howard, this is Mike Howard's own affidavit. Do y'all see how detailed his affidavit is? And I heard that Toby Shook from Thelma Alex Anderson has not even submitted his affidavit, and it's been 30 days. Let's see here. You listening to Judge Cottrell so cocky that he told Mike hold to go and draw up those appeal papers because you know the verdict is guilty alleged. Okay, we don't need to do alleged no more. Why such shit? Not this deep. Why such surprise? I'm saying I'm surprised, but I'm not surprised. But I'm surprised in the length that they went, and they called us crazy. They said we was making unnecessary noise. They said that we was just taking up for a murderer. Y'all know what they said over here and all the other channels. You dreaming. Toby Shook, and yes, they said Roach doesn't want to recuse. Yeah, he already denied it. La La Land. Who La La Land? Mike Howard. The phone call is what's needed. Let's see here. What's wrong with Mike Howell? He acts as if he's trying to help the prosecution deny the appeal. He's proving independent counsel. So what he's doing is he submitted this affidavit to Karmelo Anthony new legal team on what went behind the scenes. So yeah, they basically cut off his legs, his arm, and his heads. But like somebody said, he had to agree to this. I want to know what they had to agree to him. Was he attacked by bright flashing lights? They're getting jobs at the prison. This was obvious. I see him. They are still out there saying he's guilty. Okay. It doesn't matter to them that it was fixed. Listen, okay, building careers on cases. Come on with it. Facts based disorder like epilepsy and autism has an impact on a person's sensory. Right. Response. That's why forensics and neuro. And as you see, it was agreement not to bring none of them in, not one. Now, let's go ahead. On May 11, 2026, Mr. Wilski, Drew Mitchell, Mr. Shook, and I discussed the proposed agreement again on phone. Let me tell you what, Mike Howard. You should have picked up the phone and called whoever lawyers called when such a travesty It's been discussed. Mike Howard, not one time did you entertain this on May the 8th in your own words, right here on May the 8th. You also entertain this again on May the 11th, 3 days later. Mr. Wilkie, Drew Mitchell, Mr. Shook, and I discussed the proposed agreement by phone. I informed the prosecution that we had an informal agreement on the proposed agreement, but that we needed to have a final conversation with Mr. Anthony and whoa, oh one. I informed the prosecution that we had an informal agreement on the proposed agreement, but that we needed to have a final conversation with Mr. Anthony and his parents to confirm the final agreement. Justine, 57 minutes, Exhibit 10-6, Karmelo Anthony parents. During the phone conversation, Mr. Wiki confirmed that the agreement would extend to the sentencing phase of the trial. Y'all, that no wonder he got 35 years. So that means if you couldn't bring in the reputation, good or bad, of Karmelo Anthony during the trial, that means that he could not express who Karmelo Anthony was. Now we understand why the mother was only asked 2 questions and why nobody was brought in to speak on Karmelo Anthony's behalf during the sentencing trial. Y'all remember when I did that video and I said that one of my reasons why Karmelo Anthony didn't take the stand himself is because once he got up there, they was going to see exactly who he was. They was going to see how well he spoke, how memorable he was, and it was going to cause doubt. God dang. Oh my gosh. During the phone call, Mr. Wiki confirmed that the agreement would extend to the sentencing phase of the trial as well. Mr. Wilkie said that would mean that in accordance with the agreement, the prosecution would quickly rest its sentencing case in chief without going into any allegations listed in the state's notice. Mr. Wilkie said, however, that he would not allow a false impression to be presented to the jury by a defense witness, and that if such thing occurred, he would respond by going into character, reputation, and evidence from the state's notice. After the defense asked about Anthony's family members testifying at sentence, Mr. Wiki agreed that the agreement would cover Mr. Anthony's mother testifying to the standard. Oh my gosh. Oh, you mean to tell me that Mike Howard, and you mean to tell me Karmelo Anthony's mother agreed to this? She only agreed to say these 2 sentences. I love my son, please show him mercy. Type testimony, but no further. Mr. Wiki agreed to the agreement would cover Mr. Anthony's mother testifying to the standard. I love my son, please show him mercy type testimony, but no further. Give me a second, y'all. I'm really trying to wrap my head through this. So not only did Karmelo Anthony defense team agreed to this, his mother, oh my gosh. Oh gosh. Let me read the comments. Just let me read the comments. Just let me read the comments. I got to get my mind together. Hold on. This is why they were selling documents faster than could be produced. He's a scared kid. He agreed to anything. Karmelo Anthony didn't agree to this. It was his parents. It's his parents. I told you somebody is going to prison and Karmelo is going home. So they used to get away with this mess, but they mess with the wrong one. God is on this. Demons entertain anything the devil wants. Come on with it. All his lawyers must be so. Yes. To all the truth haters, deflectors, and racists. Come on, Tessa. We, the people, do not care about your words, your world of self-perception. Y'all are mad because God has moved on Karmelo's behalf. Yes, 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 yes. The wickedness is gross. Wickedness. Isaiah 60. I agree. They wanted to hide who those twins were. Yes. And notice how no recorded call has been leaked from Karmelo in prison because Karmelo is telling his parents the truth on those calls and they were hiding them. But you know who else can get those? His new legal team. Because everything is recorded. All he got to do is request. Subpoena Karmelo's Anthony calls. He got them. Karmelo's parents had a snake trader plant close call made in bringing in Mike, hold Toby shut. They would play. Come on with it. I hope this case ends up. Yes. I'm pretty sure the Supreme Court is like, what? You said what happened? Y'all, guess what? You remember I've been talking about a federal takeover since the first 3-4 days of this case. If the Supreme Court, if anybody in the Department of Justice say what? They did what? Y'all, the federal government, I don't want to, let's just keep reading. Let's just keep reading. Hold on. They didn't even try to prove that Karmelo. Thank you. Yes, Lord have mercy. Yes. Yes, they control what this mother had to say and the questions she got him. Let me tell you one thing. As a mother, I would have said, Mike Howard. Oh, you want me to say that? Okay. Mike Howard, you just want me to say that? Oh, and we good. I would agree to everything, knowing that they had that type of agreement behind the stands. Oh, okay. Mike Howard, that's all you want me to say? Oh, I would have been up there in my best. I would have went up there in my best outfit, sitting up there, the first 2 questions. And then I would have said, by the way, I would like to add, this is my son who has a 3.7 GPA, 21 scholarships. He saved somebody's life. He's a very good son. That is my son. Yes, I want you to have mercy on my son, but my son is a good one. My son is raised in a Christian home. Oh my gosh, I would have been spilling my own son's wrestling. Look, they would have had me put me in contempt of court. I would have been up there and I would have said, and by the way, they got an agreement behind it. Oh my gosh. Listen, the media, let me tell you one thing. Now, Miss Anthony, I don't know who you are, sweetie. Let me tell you one thing. I don't know who you are and how they scared you up. And I'm so sorry, so don't take this the wrong way. But let me tell you one thing. And since we know that you only said this on the stands, you shouldn't have went. Oh gosh, I'm trying to hold it. They couldn't do my son like that. And first of all, you couldn't tell me how to even answer questions regarding my son. Is this all was this? Mothers and fathers in the room, please put in the comment if y'all would have followed your defense attorney who you paying hundreds of $1 million to not say nothing about your son or your daughter when their life is, oh my gosh, when their life is on the balance. Y'all, if I didn't see this with my own eyes, now I knew it was bad, but I didn't know it was this bad. And she agreed to it. Let me tell you one thing. Even though I would have been found in contempt of court and the bailiff would have had to come put me in handcuffs, I still would have been, this is my son. Don't do my son like this. I would have been screaming it because you know what? Even though the media wasn't in there and cameras weren't in there, I know it was some podcasters over there. I knew it was somebody from YouTube over there. I knew it was somebody from X over there. I knew it was somebody from here over there. Independent media contributors. I would have said, write it. Right, I'm screaming it for my son's life. Karmelo would listen. Ain't no way they would have had me turn on my son like this. Hold on, hold on, hold on. Ain't no way. Ain't no way. Ain't no way. Ain't no way they would have to on my son. Ain't no way. 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 Ain't no way they would have had me turn my son like this. Hold on. Ain't no way they would have had me turn on my son like this. Hold on. On May the, hold on. Let me turn from that. Throw the whole court away. The Anthony probably scared to death for their children. I don't believe his mother agreed because she simply didn't know. How you tell a mother what to say about her son? Yes, she should have been free reign to talk about the worth of a son. Come on with it. They scared that the judge. They scared the judge to. Amen, God. That's what happened when you let the state of Texas run wild with injustice and illegal activities. They should have out. Yeah. Yes. That he had would be good. The Bible said fear is torment. I believe she was scared for her other children. But her other children was not on trial. It's not on trial. With a punishment range of 5 to 99. Her other children was not even in middle school from what I know. But her oldest was sitting up on that stand with a range of 5 to 99. Scared or not, I would not. This was very diabolical. Seriously, I would have, yes, Kara, I would have been held in contempt too. Ain't no way. Yes, Karmelo Anthony, sorry, yes. Girl, I wouldn't, thank you. I wouldn't have shut up. Listen, I would have been still talking. I would have been talking when they would have put me in handcuffs and they escorted me out the courtroom. The serpent came to his mother. Ooh. And Eve in that garden and punished her. Now she fell. Oh my God. Now God has to intervene because she, right. Let me get myself together. Because she probably was warned by others about Karmelo Anthony. Listen, the bishop, when he was on the Keisha podcast, he said he went to his father and his mother and said, please don't choose Mike Howard. He said, don't choose Mike Howard. He said, I gave them a list of other lawyers to go through. And even when they went with Mike Howard, he said, please, he said, I beg the family, please put him on the stand. You got to put him on the stand. And they didn't listen to the bishop. Oh my gosh, I'm nauseous. Hell no, come on with it. Come on, God gonna move this thing quick, praise to God. Oh my God, they screwed them up a big time. No, hell no. Come on with it. No, I wouldn't have followed. Come on with it. Come on with it. Ain't no way. Put me in contempt. Put me in contempt. I don't know, because you mean to tell me, listen, like I said, even if content, I would have got arrested, but I would have had YouTubers. It was YouTubers, podcasters, independent podcasters in there. They would have wrote up the story that, hold on, Karmelo Anthony's mother said that they told her to do this, but she went out there held in content. Oh, she was praising her son. Listen, I would have had my own record and my own day in court, but trust me, by the time I got in them handcuffs and before I got escorted out of that courtroom, everybody would have known about the deal between the defendant and the prosecutor. Mike Howard is trying to save his ass right now. That's why he's giving up these details, because he know he's about to be disbarred, and you had the audacity. Mike Howard, let me tell you one thing. You could have went and talked to his mother and his father. Matter of fact, you could have told the prosecution, yeah, I talked to him. Sure, yeah. They're going to go along with everything that I say. Yeah, you could have even lied to Bill Willis, what his name is, and said, oh yeah, Karmelo Anthony family, yeah, they already know what to say. Yep, the mother already know what to say. And when, before she got on the stand, I would have said, ma'am, this is your time. Tell the courtroom about your son. I'm going to ask you one question, and I'm going to leave it open. And I want you to express who your son is, because, hey, the fix is in. I'm telling you right now, the fix is in, but I'm not part of this. I'm your defense lawyer. I'm your son's defense lawyer. Ma'am, when I ask this question, I want you to start telling everything about Karmelo, because the fix is in. Mike Howard, you could have tricked up the trickster in this case, but you actually had the audacity and the confidence to call Karmelo Anthony's mother and tell her this. Y'all, it's so many guilty parties in this right here. Let's keep going. Let's keep going. Thank you. Let's keep going. I would have played cool. Come on with it. Come on with it. That's what I'm talking about. Come on with it, Rachel. I would have played cool till I got on the stand to speak on his behalf, speaking with love. Come on with it, Rachel. Oh my gosh, the prosecutor lied to Howard, and they had some surprise information about some sad family violence in the Anthony home. Howard didn't want that information coming out. Whoa. Now, don't come over here, Mark Rogers, please. Don't come over here. Just, if it's true, it's true. But don't come over here, because right now we having a moment over here, and the Tony Talks vested up. When we have a moment, we don't want no people coming in here trying to disturb the peace. Okay? Let me get back to this. It's sad situation for Austin and Karmelo, 2 lives ruined. The Anthony could have gotten honest work. Yes. We feel you. That's not all. She said they shortened her statement. Fear God and trust not in man. She didn't agree to it. Howard did. Well, according to this right here, and for what I know, he asked her 2 questions on the stand. And according to Dwayne that was on Keisha, she said, I love my son. Please show him some mercy. Dwayne echoed this. So that's when I saw these words right here. Hold on. When I saw these words right here, Mr. Wiki agreed to the agreement that covered Mr. Anthony's mother testifying to the standard. I love my son. Please show him some mercy. Now, the first time I heard this was on 4th of July when Dwayne was on Keisha. So when I saw these words, I said, you mean to tell me she actually said this? That's when I had my moment. Okay, let's go to number 7. On May the 21st, 2026, the defense and prosecution team met with John Roach in his chambers. During that meeting, both sides explained the agreement to the judge, describing it again as both sides agreed not to go into character, reputation, extra evidence as it applies to both sides during the guilt, innocent, and sentencing phase, as long as no doors are open or false impressions are given. We agreed that the best way to document such an agreement would be for the defense to draft and file a motions in Lyman applying to the character, reputation, and evidence applicable to all witnesses, so that it would cover both the Metcalf twins and Mr. Anthony, but if made public, would not trigger reporting in the media as a bad actor evidence specific to certain witnesses, thus endangering a fair trial. Oh, the devil is a lie. Lady E, you asked a question this morning about the appeal. Based on this right here, I'm going to say yes. Just by putting in that alone, endangering a fair trial, they already knew that this was going to violate a fair trial. First of all, you cannot restrict or provide any character on the prosecution or the defense side, basically a script to read, and you can't do this. This is totally illegal. Let's just keep going. On May 21st, 2026, I drafted the motion in line as described above and sent it to Mr. Wilkie by email. It was hand delivered to the judge on the opening day of trial. Can you just John Roach up there smiling, knowing that he got this in his hands, that he definitely got a guilty verdict in hand, signed, and sealed, and delivered. The defense understanding of the agreement. So let's go ahead. Let's see what Mr. Anthony said. This is number 8. Justine, 1 hour and 17 minutes. Exhibit 10, number 8. The defendant's understanding of the agreement. The defense understood the agreement with the prosecution to cover all witnesses who could call to be testified by either the prosecution or the defense about the incident that covered between Mr. Anthony and the Madcap twins and their teammates under the Mur tent on said day. And as every description by Mr. Wiki described the agreement to allow the testimony about what happened under the tent, and Mr. Anthony was obviously a witness to what happened under the tent by the plain meaning of the language. Mr. Wickley repeatedly used the defense always understood the agreement to cover Mr. Anthony's potential testimony, just as it would any eyewitnesses to the incident under the tent on that day. Following the plain meaning that Mr. Wiki words in describing the agreement, the defense stood that the agreement was to cover the testimony by eyewitnesses such as the memorial students underneath the tent at the time of the incident, Hunter Metcalf, students outside memorial tent who looked over. That's the Liberty tent, y'all. That's the Liberty tent. Outside the memorial tent who looked over and witnessed the incident, and Karmelo Anthony. Hold on. Let me move this microphone. Number 9. This understanding of the agreement was further confirmed by events that occurred after the motion in London memorializing the agreement was drafted and tendered to the prosecution. On May the 29th, 2026, after a meeting with Judge Roach, the prosecution, and the defense to discuss how the trial security would be handled, the parties discussed the timing of the state in case in chief and when the defense case in chief would start. Mr. Wilkie informed the court in defense that he estimated that it would take 3 days for the states to present its case in chief, which would have ended sometime on Saturday, June the 6th, 2026. In response, I voiced concern to the judge in front of the prosecution team that some of the witnesses the defense anticipated to call to testify was unavailable Saturday, June the 6th. I explained that in this case, I would not know until the final moment whether we would call our client for sure, but that if the prosecution rests sometime Saturday and the judge forced us to call witnesses immediately on Sunday, I may not have enough witnesses to fill up a full day of testimony Saturday. I explained that if this happened, it would force me to call my client out of order. The defense plan was to call all our fact witnesses first to establish certain facts and then conclude by calling our client to testify as our last witness. Okay, so this means that as of May the 29th, Karmelo Anthony was going to testify. So let's see what happened then. Let's see what happened. This is paragraph 10 in Exhibit 10. On Friday, June the 5th, 2026, the second day of the testimony during the state case in chief, I checked in with Mr. Wilkie about how he was proceeding and whether he would end up taking more or less time to present his case in chief than he had initially estimated. Mr. Wilkie informed me that he was moving more quickly than he had initially estimated. So the prosecution was on track to rest its case in chief midday Saturday. In this conversation with Mr. Wilkie, I again brought up the fact that several defense witnesses was unavailable on Saturday. And if the judge proceeded with his plan to force the defense to call witnesses immediately upon the prosecution resting in order to have a full day of testimony on Saturday, we would be forced to call our client out of order. This time, I did not preface the statement with perfunctory, like in any case, I won't know if I'm going to call my client at the last minute because I was not on record and was not speaking frankly with opposing counsel. Oh, now you're trying to consider opposing counsel? I was very plain about the defense intention to call Mr. Anthony to testify and how the judge proposed schedule requirements were going to force us to call Mr. Anthony out of order. I don't independently recall what time on Friday, June the 5th, this conversation was with Mr. Wiki occurred, but it must have occurred just before noon because I sent an email to Michael Mowley describing the problem we was facing and asking Mr. Mowley to draft a brief for us to argue to the judge that he couldn't force us to call our client out of order. Number 11, let's see how. Okay, some white page. All right, number 11. Throughout the morning and early Saturday on Sunday, June the 6th, Mr. Shuck and I repeatedly checked in with Mr. Wiki to get an update estimate. I don't see not one time that Mike Howard is talking about Karmelo Anthony legal rights, his civil rights, his constitutional rights. Not one time have they talked about Karmelo Anthony even as a defendant, as a human in this case. Mr. Shook and I repeatedly checked with Mr. Wise to get an update estimates on when he may rest his case in chief, each time referring to how the judge's plan was going to force us to call our client out of order. Number 12. Besides, the defensive team repeatedly mentioned in front of Mr. Wiki and the rest of the prosecution team that we intended to call our client to testify, even if it meant that it would be out of order. Mr. Wiki's own actions and arguments made it clear that he knew full well that we intended to call Mr. Anthony to testify. So what happened? Even before both sides tendered their notice of and arguments in favor of admissibility of character, reputation, and extra evidence pertaining to the other side witness, Mr. Wiki made references to understand that the defense sought to introduce character and reputation evidence about Austin and Hunter Metcalf, and that was uncommunicated known to Mr. Anthony via the ambiguous aggressor rule. You see the case? The ambiguous aggressive rule and the admissibility of uncommunicated character and reputation evidence of the decedent in a murder case are all part of self-defense argument. Torres discussed in depth how the ambiguous aggressor rule allows the defendant to put on uncommunicated character and reputation evidence before and after a defendant testifies. Mr. Wilkie repeatedly brought up Torres in discussions with the defense team in the months leading up to the trial, stating that while he thought the judge would rule correctly, y'all, the fix was in. Mr. Wickley repeatedly brought up Torres in the discussion with the defense team in the months leading up to the trial, stating that while he thought the judge would rule correctly and not allow the evidence, he conceded that character evidence could not be allowed. This repeated discussion of Torres and how it may apply to the trial, showing that Mr. Wiki was well aware of at least the possibility of Mr. Anthony testifying in order to argue self-defense. Okay, this was the entire purpose of the agreement, in that it provided value to the prosecution, limiting the defense from presenting damaging character and reputation evidence against Austin. This was the entire purpose of the agreement, in that it provided value to the prosecution, limiting the defense from presenting damaging character, and represents evidence against Hunter and Metcalf and the defense. From the defense perspective, the entire agreement centered around the defendants testifying without impeachment by character, reputation, and evidence, in exchange for the defense not seeking to introduce character, oh my gosh, reputation and evidence against the Metcalf twins. Furthermore, any competent criminal trial lawyer knows that for a self-defense argument to have any chance of succeeding, the defense must testify. So that means that Mike Howard did know the law regarding self-defense cases. Furthermore, any competent criminal trial lawyer knows that a self-defense argument to have any chance of succeeding, the defendant must testify. So he knew the law. For all these reasons, the defense always understood the agreement to include Mr. Anthony's testimony free of impeachment of character come on. Free of impeachment by character, reputation, and offense, bad act, evidence, just like every other witness, other side could call to testify about what happened on the tent that day. Ooh, let's see here. My heart goes out to Karmelo Anthony mother. I would not went crazy when it came to my son. Right. They would have had to put me in jail. Yes. I believe God put Karmelo on the situation to expose the corrupted system in Texas. In fact, God got Karmelo believed. Should not agree to it. Mike Howard did. Let's see here. I have seen families who know their children may be guilty and still put up a better fight because no child make them turn. Nobody. Yeah. Yes. But why did they talk? I don't know nothing about that. I don't know if that's true or not. Fear is a spirit. That is true, Greater Cummings. I don't know if that is real or not. I don't know. This is out of the 1950s when blacks were railroaded on a daily and no one fought back, and no one expects this to happen to a family like Karmelo Anthony. 29, 25, 20, maybe you meant to put 2025, 2026. God got him, he would be home soon. When they turned on Mike Howard, he only had one play, which was the jury and his affidavit as July the 5th. If I'm not wrong, he only had 10 minutes to give. What? He only had 10 minutes to give Karmelo Anthony information. Oh my gosh. You good, buddy? There were no reported issues in the Anthony family home. This statement is a lying distractor. Okay, that's what I thought. Come on with it now. Whoever said that, hey, moderators, I hope y'all got that person name. If that person come in here with some more lies, block them immediately. I've been scared before, so scared you have panic attacks. I understand, Greater. I understand. They were afraid of those racists. Good evening. Hey, how you doing, Teresa? Annex for months. Okay, I got you, Greater coming. I'm sorry about that. Ooh. Howard said, hold on. She only said that because Mike Howard said that Karmelo has something in his record that can harm him. That's why she said what she said. That's showing her statement. He definitely went as worse as those Metcalf twins had delivered. Marcus is absolutely right. She didn't agree. It was Howard. Okay. I'm going to keep reading about Anthony lawyer agreeing to the statement you just read. Lawyer did not know his client at all. Sickening, disgusting, disgraceful, but God will prevail. No adult in sight until Karmelo's arrest. Let's pray the appeal court is not corrupt. Because even if, let's say, the regional judge denies the motion for trial and recusing Judge Roach, there's another court they can go to, and they can actually go up to the U.S. Supreme Court. So, um, mm, mm. Hey, how you doing, Mita Lee? Students can't be left alone. It's a receipt for a disaster. A defense lawyer is to defend the defendant to the fullest, not bow down to what the prosecution went. Yes, when they know things are wrong. Come on with it. Mark Kroger is absolutely right, because when the young lady was on the freezing reading everything, that is exactly what she said. Is she told Mike Howard that Karmelo had something in his record. The judge and prosecutors gave Jeff McCallum. Yes, buddy. I can't even say that better. And Tony Talks vested up. Love you and what you're doing. Thank you so much, Jerry. Keep on going through the document. It would be clear why Karmelo didn't testify. Come on with it. And why Cockroach got away with this BS. Okay. Interesting. But the dream team is getting, facts. His attorney agreed with this BS. Yes. Karmelo family wasn't on trial. The prosecution didn't want to go into character because, right. Which would have helped his self-defense case. Ooh, okay. So a kid with epilepsy was being bullied. Yes. Unethical. Karmelo was supposed to be called to the stand, yet it's changed in the last 10 minutes. Okay, let me keep reading it. They made Karmelo Anthony aggressive, therefore he could not use ambiguous. Is that what the ambiguous aggressive rule is? I need to look that up. A kid with epilepsy, yes, humane, yes. And so that means that the defense knew that, Judge Roach knew that, and Mike Howard knew that, and they agreed not to call no expert witnesses. Because it would look in favor to Karmelo Anthony. His attorney gave him no effort to defend Karmelo. Now he's trying to, yes, that's what he's trying to do, defend his law license. Mike Ho, you're dead wrong. You know Karmelo shouldn't have, he should have taken the stand to help his self-defense. He was a good, right. Why are people with, don't know. With that agreement, it was agreed that they would not call professional witnesses and could not talk about those bad, yes. Mike Howard violated his oath and must be disbarred. Yes, Katie. He's hoping to save himself by throwing the prosecution under the bus. He only reveals how ethical he was. Hellbound, you're right. A school that allows children with health issues to be bullied is not an educational institution, right? Yes. They know who stabbed. Yes. What you say, show up and show out, an impact statement by his mother to support her son, drag me out of the courtroom. Yes. She never said he had nothing. Yeah. Even if Karmelo Anthony had something in his record, that had nothing to do with the incident under the tent. I don't care what it was. I don't care. It had nothing to do with him self-defending himself that day. Okay. There's no way. The Supreme done heard about this mess. They message. Oh, it jumped. The Supreme Court heard about this message. They message is fix this injustice, period. Cause if we get involved, laws going to change. I already said that Karmelo Anthony is going to have his own law and laws are going to change. There could not have been anything so terrible. Right. That's what I just said, Katie. Mike Howard helped protect those twins. He didn't know we would call them out and not let it go. God is good. Come on. Yeah, it wouldn't had to be drugged out. Hold on. Something just hit me. So something just hit me. And let me get back to the comments. I'm going to read this. So if this was the agreement, I need to keep reading because I need to see if the Karmelo Anthony family agreed to this, mother and father. Because if they agreed to this, why did they get after the verdict and say they felt like they were set up? I need to keep reading, and I'm about to keep reading because now I'm starting to feel some type of way. Yes, I would have. I know. I would have had to be drugged out and hopefully lightning would have struck inside that courtroom. Come on, Katie. Come on, Katie. We're the same type of mothers. Listen, like I said, the cameras wasn't in there, but YouTubers was in there. I don't need no cameras. I don't need no channel 6. I don't need no channel 12. I don't need no Fox 54. I don't even need Fox News. I don't need CNN. As long as I know I got a few YouTubers in there that's going to tell it like it is, I would have showed my behind in handcuffs or out of handcuffs. Judge Roach would have been looking at me calling in contempt of court, and I still would have been talking about my son. Listen, even if the ballot come put handcuffs on me, I still would have been talking about my son. It ain't no way that I would let Mike Howard, John Bill Whiskey, or even my husband, Mr. Anthony, convince me not to tell the world about my son, Karmelo Anthony. I'm sorry. I'm sorry. Karmelo Anthony was working with the other side the whole time. It was fixed for him to go to jail. Come on with it. Come on with it. Come on with it, Uncle Charles. Thank you for that. Birmingham, Alabama in the house. Wow, come on. I knew that attorney was working with the other side by him. Come on with it. Come on with it. Amen. Let's go ahead. Okay, 13. All right. Justine, I'm calling on you again. Exhibit 10, paragraph 13, at 1 hour and 37 minutes. Throughout the trial, the defense revised its trial strategy in reliance upon this agreement. Let me leave amen up there because I may need it in a few minutes. Absence from the agreement, the defense intended to cross-examine. Okay, hold on. Absent the agreement, the defense intended to cross-examine each memorial student witness the prosecution called about Austin and Hunter Metcalf character reputation for violence, for being bullies, and racism. That means it was a history. Now we know this, not alleged, it's a history. Where is Nancy Grace and Metcalf? John Metcalf, Jeff Metcalf, where's Megan Metcalf, where's everybody that donated $1 million+ to these bully sons that had violence tendencies and racism? Where's everybody that donated $1 million+ to this family of bullies, violence, and racism? Where are they now? The chats are so quiet now. Because you know what? They're looking at the same document we're looking at because they're trying to find evidence that the judge and the prosecution in Collins County did right by Karmelo Anthony. But while they're reading like the same time they're reading, they're starting to feel foolish. Didn't I tell y'all last week? Didn't I tell you that white America and a sector of Black America, didn't I just say that sector, that they was going to feel like they was shammed and bamboozled when the truth came out about this case and them sons? Didn't I just say that? I said white America, the ones that really was trying to help this family and try to find out exactly what was going on under that tent, because I told you what they said in that audio clip with Megan. I said, you know what? I just said this last week. I said, hey, there's a portion of America, that sector of America, when they find out what exactly happened, they're going to feel bamboozled. They're going to feel angry and mad, and all hell is going to break loose. Them people gave up $1 million to a racist, a domestic violence abuser. Let me get myself together. Cause just bear with me. I want to get through Exhibit 10, and I'm gonna let you go because I can't sleep because I gotta keep reading. So if you need to come back and watch this tomorrow, come back, but I'm gonna keep reading. Absent from the agreement, the defense intended to cross-examine each memorial student witness. The prosecution called about Austin Hunter's Metcalf character reputation for violence, being bullies, and racism. The defense also intended to cross-examine these witnesses from various statements that they had made to the police on April the 2nd, 2025 regarding Austin Hunter Metcalf from being easily triggered, having a loud mouth, being passionate, and not allowing themselves to be disrespected. So y'all, so it was some students under the tent that was trying to do the right thing. Now that means that for sure, 100%, because this document is public. So that means that Judge Roach, guilty as charged. The DA, guilty as charged. The Texas AG, Ken Paxton, guilty as charged. You had to deal with this case too. And that also means that, what's his name? Fallon, Patrick Fallon, guilty as charged. Because you did a whole lot to try to cover up as a U.S. Senator, a House of Representative, guilty as charged. You did a whole lot for the Metcalf family because of what happened to Austin under that tent. Let me tell you one thing. Now that this appeal packet is out here, Fallon, Patrick Fallon, you need to go ahead and make a statement in the next 24 to 48 hours and say you didn't know none of this. Because if you don't make this statement by Monday morning, that means exactly you knew what would happen under that tent and your son was involved and you abused your power to cover up this atrocity and this corruption that happened in Collins County. Patrick Fallon, you are on the clock, sir. You are on the clock. Let's keep reading. Oh, you better say your son was one of the witnesses that tried to tell the truth and that would have came up on the stand to defend Karmelo Anthony. You better make it clear. You better make it clear and plain. For some specific examples include Austin's a really big guy and he's kind of like an aggressive guy on the team. Guilty as charged. Austin got the same way that he got during the altercation is the same way he got with us. Guilty as charged. And the Mellow kid is something or someone, and then Austin kind of got triggered. Guilty as charged. Hunter and Austin, they're not going to let you disrespect them. And Austin, he's like a big guy that nobody really wants to fight. Guilty as charged. And Austin, a really passionate guy. And Josie, we got a name. And Josie told the police about Austin's history of fighting and almost getting kicked off the team for fighting. Guilty as charged. Guilty as charged. I've known Austin for a while, and if Austin is about to get in the fight, you can tell. It seems like something was redacted. Austin can be a bit aggressive at times, and he has a bolder mouth sometimes. Number 13, 15. If the prosecution did not call any of these witnesses, the defense was ready to call them during the defense case, in chief, and question them about hostile witnesses. Furthermore, the defense intended to call witnesses familiar with Austin and Hunter's reputation for violence and bullying. Guilty as charged. The defense intended to call witnesses who themselves were victims of the Metcalf twins' violence and bullying. Guilty as charged. The defense intended to question Memorial High School teachers about the Metcalf twins' disciplinary history contained in their school records, which corroborated their character for violence and bullying. Guilty as charged. And finally, the defense intended to elicit testimony about the Metcalf twins' arrest for racist graffiti. Guilty as charged. Amendment 16, in good faith reliance upon this agreement, the defense did none of this. Oh, Mike Howard. The defense even limited its questioning of witnesses about statements they made about Metcalf twins. So all of those 21, so let me tell you one thing. I'm the type of person that I'm willing to say, I apologize. Those 21 witnesses that got on the stand, A lot of them was prepared to tell the truth if Mike Howard would have asked the right question. And Mike Howard just admitted that he limited the questions to some of the witnesses so they couldn't tell the truth about Austin and Hunter Metcalf. But it's definitely in this document right here. Okay. Limited is questioning of witnesses about statements that they made about Metcalf twins being triggered, loudmouth, and being passionate, etc., that had been deemed to allow under the agreement in an abundance of caution to avoid opening the door. Furthermore, because the prosecution had made it very clear that the defense calling any psychological related, here we go, expert would open the door to character, reputation, and evidence pertaining to Karmelo, the defense chose not to designate any experts and ultimately chose not to call as a witness a neuro psychologist to discuss Mr. Anthony epilepsy impacted his perception of threat and response, as that is relevant to self-defense, and a forensics psychologist to discuss both brain development of a 17-year-old as well as the fight or flight response as it replied to Mr. Anthony's actions. Y'all, you remember we discussed that too about what the Supreme Court said about 17-year-olds and under brains development. And I said, well, Mike Howard, you could have used this. But now we know why Mike Howard didn't bring none of that up. I want to get down to the parents. Let's go. Number 17, as a result of this revision in a defense strategy, the defense did not go into these subjects doing voir dire or opening statement without such an agreement, or if the defense had suspected that the state would violate this agreement, the defense would have explored these subjects doing opening statement or would have introduced these topics during this opening statement. In sentencing, in reliance upon the agreement, the defense did not designate an expert who was ready to testify regarding mitigation. This is why he didn't even prepare for the punishment phase, i.e. risk assessment and psychological profile of Mr. Anthony. Furthermore, in reliance upon this agreement, the defense severely limited its available character witness to just 3 questions. Here we go. 3 questions to Mr. Anthony's mother, which had been previously agreed upon by the prosecution. Other than general character testimony and plea for mercy, in reliance upon the agreement, the defense also did not go into substantial family violence Mr. Anthony had witnessed and been a victim in his home. What you say? Other than general character testimony and plea for mercy in reliance upon this agreement, the defense did not go into substantial family violence Mr. Anthony had witnessed and been a victim of in his home. Can the parents, according to this prayerful soul, I don't know if you're still in the room, but I don't think the parents will have a right to sue Mike Howard or try to recoup any of their money. Not based off this. Not based off this. Still claiming he's guilty. They don't care nothing about that. It's okay. Hey, how you doing? How you doing, Deep? There was nothing they could do. So whoever that Vesta was that came in here about the Anthony family violence, you were right. There was nothing they can do to you either for speaking up for your child. They are at a clan. Oh, I see what y'all saying. I see what y'all saying. Right to nothing. It's a record. The Anthony needs to sue the school district because they did not have adequate adult staff to supervise students for safety and help prevent any conflicts or injuries. Now I can see them doing that. That's not new to us. Eddie Parra didn't like Carmelo Anthony dating his cousin Valerie Perez. The reason they set Carmelo up, I don't know about that, Zane. They've been doing that. Yes, Ben Crump can sue them for violating his oath, which yes. Now that part, Ben Crump is already suing Mike Howard for violating Carmelo Anthony's civil rights. You ain't seen nothing yet. Keep reading. The witness statements given to the police is totally different from what they said. Okay. If it was my child, they would have been taking me to jail. Come on with it, Regina. We just said that too. I got it. I removed his name. No, actually, it seemed like Mark was telling the truth. Lady E, it seemed like Mark was telling the truth. Mark was telling the truth. Mark, if you are still listening, I'm going to go behind the scenes and I'm going to remove the remove the X from your name. So sorry about that. Sorry about that. Sorry about that. Wow, I told you a phone is still out there. He was in on it. Lady E, yeah, down that it was some witnesses that was going to actually testify for the defense. Yeah, I believe that some phones are out there. Lord have mercy. The skinny lady said ninja to a baby and got paid. Austin got the same way during the altercation like he gets with us. Yes, aggressive. They are so evil they may have threatened to really hurt Carmelo if the Anthony's put up a struggle in the courtroom. Well, it seemed like, according to this, and I hope I'm not misreading this, they went along with it so that their family business did not come out in court. Other than general character testimony and pleas for mercy, in reliance upon this agreement, the defense also did not go into substantial family violence. Mr. Anthony had witnessed and been a victim of in his home. Oh my. I knew the dad was a racist the day he came to the press conferences like he had the right to be there when like he was entitled. Okay, I got you. You're right. Everybody remember that day because he had broke his arm. It's sad that there's a lot of lawyers, court appointed, that would ask the defendant to just take pleas whether they are guilty or innocent in Texas. This case is showing what's been going on. I ain't know it was this bird. They are all singing like birds. Come on with it. I told you, brain development isn't an excuse when a person says, touch me and see what's happened. Let me tell you one thing. Let him breathe. Let him or she breathe. I really don't care no more. They can come over here and say anything they want to say, but they can't deny Austin and Hunter's bullying, violence, and racism. Don't block nobody else. Can you? Never mind. It's above your head. And it's above you too. Judge Roach need to be locked up. Metcalf, your grifting days are coming to an end. And Nancy Grace can't help you. She is irrelevant. Megan, keep your piece of shop. Job, Hunter, keep your piece of shop. Carmelo going to college. Come on with it, Bunny. Come on. They knew the outcome. One. Good. Ooh, I agree with y'all. However, with that gag order and the secret agreement, the Anthony's being quiet was the best thing they could have done. They wanted us to act. I'm still watching. Okay, you good? You still in here? Okay, gotcha. Now that doesn't sound right. Number 17. Let's go ahead and number 7. But I guess we won't really know. As a result of this revision in the defense strategy, the defense did not go into the subjects doing or open a statement without such an agreement, or if the defendant had suspected that the state would violate the agreement, the defense would have explained explored these subjects doing opening statements. If the prosecution would have brought up Karmelo Anthony characters or reputation, something that was not favorable in his stance, I guess he said he would have brought it up against the Metcalf twins, basically. If they would have brought up anything in Karmelo Anthony's past or his family activities, Mike is basically saying that he would have did the same thing to Austin and Hunter Metcalfs regarding their background, histories, reputation, and family activities. Okay. Now let's keep reading. Justine, Exhibit 10, number 19, 1 hour and 54 minutes. Wow. Here we go. Now we're getting into the court. This is the court. 19 on Saturday, June the 6th, 2026, after the prosecution rested in case in chief. The defense called witnesses Adam Linwood. Oh, we getting names. Jeremiah Smith, Jose Ranez, Ramones, Mora, before ending the day in the late afternoon, evening. So we got 3 witnesses. Okay. On Monday, June the 8th, 2026, the defense resumed its case in chief, calling Brandon Stephens and Brendan Lacey. The defense planned witness, so this is 5 in all, planned witness redacted, had been violating the defense subpoena and kept changing the time he told us he would arrive at the courthouse. Accordingly, after Mr. Lacey's testimony, we took a break at 10:15 to see if blank had arrived. Why did they redacted it? Why did they redact it? During the 10:50 a.m. break in the back hallway outside of the judge's chambers, the judge asked us for an update about timing, how many more witnesses, etc. I explained that the net witness the defense had planned to call was a Centennial high school coach, period. Mr. Whiskey asked if the coach would testify to that did not pertain to Mr. Anthony's character. I explained that this coach had witnessed Mr. Anthony's seizures, so he would testify about Mr. Anthony's epilepsy based on his personal knowledge. Mr. Whiskey then argued that testimony about epilepsy was irrelevant and guilty or innocent, and to the extent it was relevant, would open the door to character representation and extra outside evidence against Mr. Anthony. In plain terms, it would breach the agreement. I stated that I disagreed, explaining how it was relevant for Mr. Anthony's state of mind pertaining to a self-defense, and it did not relate to character, reputation, and extra evidence in any way. But Judge Roach agreed with Mr. Wilski that he thought testimony about epilepsy was not relevant due to a guilty or innocent, and would open the door to character, reputation, and extraneous, maybe that's it, evidence. Based on this, I informed the court that I could not call the coach, and I was anticipating having 1 or 2 witnesses before I would call Mr. Anthony. In response to the judge's question about likelihood of Mr. Anthony testifying, I told the judge that we would need to confer with Mr. Anthony about his Fifth Amendment decision regarding testifying, but I was 99% sure he would, in fact, testify. Well, okay, well, what happened? After the break, back in court before the jury, to give blank more time to arrive at court, we then called Frisco Police Department Detective Riley. That's the one that talked about the multi-tool to testify. After Detective Riley finished testifying, I then decided not to call blank as a witness, and we broke for lunch early around 11:17, and the prosecution and defense team stayed behind to talk to the judge outside of the jury present. Let's keep going. Okay. 22. On the way back to the chambers, Mr. Whiskey mentioned that Mr. Shook, from his perspective, I had already opened the door to character, reputation, and evidence pertaining to Mr. Anthony by saying that Mr. Anthony was a member of the chess club. During my opening statement, I did not say anything about chess club at the time. During my opening statement, I said that Mr. Anthony played chess during my background description of him and his hobbies. Mr. Wilski also stated that from his perspective, the agreement did not cover a testifying defendant. Oh my gosh. Hold on. Y'all, let me go ahead and prepare myself. Mr. Shook alerted me, and Mr. Wilkie, Mr. Mitchell, Mr. Shook, and I stood in the well of the courtroom, and Mr. Wilkie repeated these statements, adding that the prosecution never thought that the defendant would call Mr. Anthony to testify. Back in the judge's chamber, Mr. Wilkie repeated his assertion that the agreement between the prosecutor and defense never testifying a defendant. He elaborated, stating that he never thought we would call Mr. Anthony as a witness. He also repeated his claim that I already violated the agreement during my opening statement, saying that Mr. Anthony was a member of the chess club. It was important to note that this was the first time Mr. Wilkie mentioned that he believed I violated the agreement days earlier by mentioning that Mr. Anthony played chess during my opening statement. So if opening statements was on June the 4th, and he's bringing this up on June the 8th, we're talking about 5 days. So I see what Mike Howard talking about. Although the prosecution and the defense team had conferred many times throughout the prosecution case in chief about various topics, issues, this was the first time Mr. Wilkie brought up his assertion. 23. Judge Roach told both the prosecution and defense team that my mentioning chess during the opening statement, did not open the door to character, reputation, and evidence applicable to Mr. Anthony. The parties argue about whether the agreement between the parties covered Mr. Anthony testifying. The prosecution repeated their position that it did not, and that if we call Mr. Anthony to testify, character, reputation, and evidence pertaining to Mr. Anthony were in play. Okay. Furthermore, Mr. Wilkie stated that at this time, the prosecution had already arrested, character, reputation, and evidence pertaining to Austin and Hunter Metcalf was not relevant. So Mr. Shook and I mentioned that ambiguous aggressor rule from Torres. Mr. Wilkie argued that Torres did not apply because it was not ambiguous who was the first aggressor. What? Whoa. When Mr. Shook and I mentioned that the ambiguous aggressor rule from Torres, Mr. Wilkie argued that Torres did not apply because it was not an ambiguous who was the first aggressor was. That the first aggressor was clearly Austin Metcalf. Justine, Exhibit 10, paragraph 23, at 2 hours and 5 minutes. The prosecution just stated that they knew that the first aggressor was clearly Austin Metcalf. Let's keep going. At this point, the discussion devolved into a number 24, and the prosecution team agreed to take 10 minutes to cool off before attempting to renegotiate parameters of how the agreement could extend to Mr. Anthony's testimony. Should the defense now choose to call him? After the 10 minutes cooling off period, Mr. Wilkie and I met in open court outside the presence of the jury and without the public in the room to discuss possible parameters in agreements covering Mr. Anthony's testimony. Let me tell you one thing. Oh, this right here is stupid. You wasting time. Given Mr. Wilkie expansion view of what he considered would open the door to character, reputation, and evidence pertaining to Mr. Anthony, especially he repeated claim, even after the judge stated otherwise, that even my intention of playing chess opened the door to character, I resolved that my only choice was to go over my plan outline of Mr. Anthony's direct examination line by line. When Mr. Wilkie determined what would, see, I don't got time for this. Mike Howard better than me. First of all, I wouldn't even agree to this. In Mr. Wilkie view opened the door, I would have never taken a drastic step of previewing my strategy and even my questioning with the prosecution. But as a defense team, we agreed we had no other option if we wanted to try and reach an agreed understanding with Mr. Wilkie on how to renegotiate agreement would cover Anthony's testimony. Let me pause right here. You mean to tell me that this whole entire court room, from Judge Roach, the DA, Wilski, Greg Willis, Howard, Shuck, they're more concerned about an agreement versus Karmelo Anthony, livelihood, fair trial, impartiality. They're caring more about a damn agreement versus if the young man, and as you see, the prosecution already said that the first aggressor was Austin Madcow. Oh my gosh. Let's keep going. Let's keep going. Let's keep going. Number 25. As I went through my outline with Mr. Wilkie, reading the outline over my shoulder, Mr. Wilkie declared various subjects. This is Exhibit 10. In his view, would open the door to character, reputation, and evidence pertaining to Mr. Anthony. During this discussion, Mr. Wilkie repeated his claim from my earlier mention of chess opened the door. While I disagreed all of Mr. Wilkie's assertion of the subject that opened the door, I agreed to cut them from my questioning in hopes of salvaging the agreement to keep Mr. Anthony's Mr. Anthony's extraneous offenses out if he testified. At the end of this discussion, with the understanding that Mr. Wilkie would extend me leeway to lead Mr. Anthony more than normal through certain aspects of the testimony in an abundance of caution to avoid opening the door, Mr. Wilkie and I informed Judge Roach that we had to come to an agreement as to how to renegotiate the agreement that would cover Mr. Anthony's testimony. We then summarized the process we had just gone through and our renegotiated agreement on the record. Okay, number 26. Prior to breaking to allow the defense to retire to the defense room to discuss the issue with Mr. Anthony and his parents, y'all hear this? To discuss the issue with Mr. Anthony and his parents, Judge Roach informed us that he was aware of no mechanism at his disposal to enforce the agreement between the parties. Furthermore, Judge Roach informed us that he saw no way if Mr. Anthony to testify without the door being open. For example, if he said that he brought the knife by accident or was scared to use it, etc., that this was almost certainly open the door to character, reputation, and extraneous evidence of a sort. To clarify the issue, I proposed the hypothetical scenario that if Mr. Wilkie claimed that agreement had been breached in some way, if I or even the judge felt that Mr. Wilkie was operating in bad faith, that the judge stating that he could not enforce the agreement would have to make a ruling based on Texas rule of evidence alone. Didn't we also go over Texas rule of evidence? Let's keep going. And that in all likelihood, the door would have been open. Judge Roach confirmed that this was the case. Then we broke to discuss the issue with our client. Judge Roach gave us approximately 10 minutes to explain the breakdown of the agreement and the proposed resolution with our client before the judge brought Mr. Anthony in for an on-the-record abolishment. Number 27. Look, how far did Mike Howard go? Okay, number 27. During the initial pre-abolishment meeting with Mr. Anthony and his family, here we go. I did my best to explain everything that had just happened with the help of Mr. Shook and Mr. Gooper. We then returned to the courtroom for Judge Roach to abolish Mr. Anthony about his Fifth Amendment rights, and also to explain that if he testifies, Judge Roach believed that he had no mechanism to enforce the agreement between the parties and would rule on the rule of evidence alone as to whether the door had been opened. They're more concerned about this agreement. John Roach then gave us 10 minutes to discuss Fifth Amendment rights with Mr. Anthony and helped him ultimately decide if he would testify. I asked for additional time to have such a complicated discussion with a 19-year-old in the most stressful situation of his life. But Judge Roach declined to extend our time before 10 minutes. So this is what y'all were talking about. Again, we did our best to explain everything, the pros and cons of testifying versus not testifying, the likelihood of winning on self-defense if he testifies versus if he did not, the likelihood of whether we would get an instruction in the jury trial of a lesser included charge of manslaughter and criminally negligent homicide if he did. And if he did not testify, and the likelihood of whether we could get instructions in the sentencing jury charge if we got there on sudden passion if he did and did not testify. Okay, so he went over his different options of testifying under self-defense, testifying under lesser charges, the pros and cons of that, criminally negligence, the pros and cons of that, homicide, got it, and the likelihood of getting certain passion if he got it or not. Come to find out, he didn't get none of that. He didn't get none of that. Based on what we know, he could have just testified. I don't know if this was promised, but he should have just testified. Number 28, during this discussion, beyond all of the above, the most complicated factor was whether Mr. Whiskey would claim that we opened the door, they still worrying about this agreement. And then bring it to Mr. Anthony's extraneous offenses, bad characters, acts, and reputation. Based on his actions and claims, specifically his repeated assertions, even after the judge had firmly disagreed that I had opened the door by mentioning chess, as well as his general claim that the agreement had never been contemplated, Mr. Anthony testifying, despite the plain meaning of the words Mr. Wilkie himself repeated used to describe the agreement. The defense team strongly felt that the risk of Mr. Wilkie claiming the door had been opened was too high. This was amplified by the fact that Judge Roach made it clear, should Mr. Wilkie claim a breach of the agreement, he felt that he was unable to enforce it, that in all likelihood the door would have been opened. At the end of the 10 minutes, despite our request for additional time, Judge Roach called us back to the courtroom to announce Mr. Anthony's decision and proceed with the trial. Number 29, ultimately, Mr. Anthony chose not to testify. This 108-degree change in defense strategy was a direct consequence of the breach of agreement. The breach of agreement affected all aspects of the defense case. By the time that the agreement was breached, it was too late to change our approach in the voir dire and opening, too late to ask different questions of the prosecution witness, and too risky to recall those witnesses to ask questions that would risk the prosecution deciding whether we open the door. In great hamper our strategy during sentencing, causing us not causing us to decide not to call witnesses we otherwise would have called, and severely limiting the question asked one of the questions we did in fact call. The prosecution breach of agreement directly and significantly undermined the defense ability to present a complete defense. Mike Howard signed on 30. Further, Mike Howard, there we go. And he signed this on the 5th of July, 4 days ago. 4 days ago. 4 days ago. Let me go to the comments. I got to go to number 5 and 18. And investors, I'm going to let y'all go. Justine, 2 hours and 16 minutes, the end of Exhibit 10 with Mike Howard's signature. Let me go here. We don't know what, he never testified. Because the family of these people weren't on trial, it happened in the internet. Karmelo made a big mistake, and he is paying the price. Oh, you still in here. You still in here. So there is a police report of this assault in Anthony's home, because you know they would have put it out there unless it's sealed. He's entitled to a fair trial and defense, and clearly didn't get one. Definitely didn't get one. Even Mike Howard said it basically hindered the defense case. We already knew they was racist. Tony Talks messing up. Mars and chat, salute to you, man. You came here after some shockers. But how you doing? How you doing? Whatever happened in Karmelo's family history couldn't be as right. Moving mountains. I like your name, Moving Mountains. Yes. They already knew Karmelo Anthony was going to be found. Yeah, he is naming them. Yeah. Let's see here. They didn't put Karmelo Anthony on the stand, but they put his mom on the stand. Tell it. All his freedoms was on the line. Come on. Whatever happened in Karmelo's Anthony family is irrelevant and could compare to the twins. Right. That's what I'm saying. For 35 years, tell all my business. My son is not going to jail. Tell it all. Okay, tell it all. No family is perfect, but tell it all. I don't care. They already knew Karmelo was going to be found guilty. Time to research some names is out here, y'all. True, and you know what? They're grown now. They're adults now. True, they were being agreed upon how they were going to hang him. The blank is Hannah. I had a feeling about that too. But look at the beginning of the name was M. If you go back to these redacted parts, it looks like the beginning of the name is M. Let's see here. Let's let it catch up. It looked like the beginning of the name's redacted part was an M. I hope I didn't pass it. I think by now I passed it. I let it populate. Agree. Yes, in black and white now. Okay, it wasn't this high. I let it populate. No. Okay, it's down in here. It's past this part. All the witness statements, where it also says that there was no doubt who the first aggressor was Austin Metcalf. Austin Metcalf. Here you go. So that's redacted here real good. In number 20, redacted. But if you go down to here, you see this right here? Number 21, go to number 21. You see this after the break, back in court before the jury to yield. That looks like an M or an N. It doesn't look like an H to me. I just want to bring that up. Let's see here. I use your words. The gentleman agreement was to protect Hannah and prevent right. But my son is on trial, but we trying to protect Hannah. You good? Take your time, sis. Thank you, Lord. I think the reason they didn't put Karmelo on the stand because he couldn't defend what he did. I don't think so. I didn't think. No, That's definitely not what it was. The devil is a lie. The devil is a lie. Please, they didn't want a human. Yes, at all. Period. Right. The defense would have asked him if he would have got jumped, and he would have. Oh, come on with it. You know what? If I see one of these, hold on. I said I ain't gonna block you tonight, but I'm just gonna skip over your stuff. Come on, come on, come on. Yeah, come on. You got it. A black kid to jail. Put it on the black kid. Put it on the black kid. Mello, who knew those? Well, there they attack. Why take the stand? My sister was a prosecutor in Dallas, and for some reason she didn't care for it. Nowadays she practiced zone law. I may need to talk to you behind the scenes. Tony Talk vested up compelling sports edge at gmail.com. That's right. They didn't want a jury to see a kid. They already spent the entire year of making him out to be a monster and a thug. That is facts. It doesn't matter what accomplishments or who he had. Hold on. Ghost. Don't worry, he's ghost. Why would the judge and the prosecutor not bringing up the deceased background unless they wanted to hide? That's right. The agreement was for Jail Metcalf boys and Megan Metcalf boys. That's exactly who it was for. Justine, his character has everything to do with the trial because one is alive and one is sentenced to 35 years. So therefore, prosecution handicapped the defense. There it is, handicapped the defense. Let's see here. They knew Karmelo was a good young man. Not perfect, as we see, not perfect, but he definitely was a good young man. So they didn't want him to testify again. Yes, any character witness. If the first degree murder, his mind, come on, is absolutely important. Come on with it, Brian. Come on, very important. What? Read that again? Dang, I missed this. What did you want me to read this again? They said the videos they got the testimony from the kids. That's how they knew the twins were the aggressors. But they were not going to allow self-defense by a person. Well, guess what? See, I've heard that before. If Karmelo Anthony would have got off on this through the first trial, because he's definitely finna get off on this the first trial, that means that every black foundational black American would have the right to self-defend himself. And they didn't want this to be a historical case where everybody is fighting back for their lives, especially if you're wrapped in this beautiful melanin. But guess what? But because of the injustice of this case, that means every black person walking among these streets will have the right to defend themselves against any attacks. And then guess what? That's going to push for Black America to get that hate crime that we've been asking for years. Just watch and see. He isn't their son, so why would they care? Facts. Was your father killing the finish him? Black people is not your part of the justice system. No, you're not part. You gotta be crazy. I know you gotta be crazy. Shit, I'm a veteran, and I know I'm part of the system. Whatever. Do y'all see what they want us to think? That this system, the Constitution, the Bill of Rights, and the Amendment, and the judicial law don't cover us? Don't let them. Do not give them the power, because you see, they're trying to condition us. They're trying to condition us to make us believe that we don't have rights in our own country. Don't give them that power, because I'm fighting back. Look around you. Oh, shit. Black America, I don't even know who you is. You try. Hold on. I got you. 1 second. Let me go ahead and help you, because I think you lost. Hold on. You are definitely lost. Let me go ahead and help you. You on the wrong channel. 10 minutes. Miss Tony does her research, and we know she got out the land. Hey, I'm just trying to read the thing. Like how it would continue to lie. Don't believe him. Well, that'll be between him and whoever this agreement was. That's for internal investigations. Chess plays are made by either being aggressive or empathetic, but always forward thinkers. That is okay. Forward thinkers. Judge Roach bullied the defense into making a spur of the moment. Yeah, sure did. I'm done with Mike Howard because Karmelo was a child. Hey, how you doing, Missy? How you doing? And he should have discussed it with his parents too. I think he did. I think he did. I hope I'm wrong. I hope I'm wrong. Are you listening to what his so-called lawyer is saying, or you don't care about following the law? Oh, I know you're talking to. The trial was tainted by the judge, right? See, Mike Howard didn't put K8 on the stand because it clearly, this affidavit was a chess move. He's saying that's a good way to look at it too. This was not a fair trial. They know it's not a fair trial. I have removed that person. I have removed that person. Hey, how you doing? How you doing? At the courthouse, a group handed out propaganda labeling. Now he shouldn't have. So Judge Roach allowed that, right? Labeling. Let me keep going. Labeling the murderer, and they were not sent away. White Lives Matter. Okay. Yeah, we ain't even go fight. We ain't even go fight that fool no more. He's already gone. The video shows nothing you saw. Yeah, I'm not even going. We ain't gonna address him no more. He or she, they scared Karmelo Anthony so bad he would have. Zang. That's what it read. That's what it read. The propaganda sold the 10 minutes, right? Wow. The most important day of his life, 10 minutes. The propaganda that White Lives Matter group distributed Mike Howard didn't intend it to win. Nope. Karmelo case should not have been made into trial. He was affected. Okay, Karmelo case should not have made it to trial. Also, if he was affected by his family life, did his GPA or scholarships offer? No. You're right. I got what you were saying. They wanted to restrict the case strictly on incident under the intent to hide the Metcalf reputation. Well, it seemed like that's why they hid it, because they knew exactly who those boys were. They all had to do with tell the truth and give fair trial, but they couldn't. Get the fact. I got you now. I got you. I know exactly what you're saying. M is for Mr. Metcalf. They were calling Mr. Anthony too. Oh. But Mr. Anthony was in the courtroom. Mr. Anthony was in the courtroom. They said it was a coach. It was a coach from Senator High School that they was waiting on. It was a coach from Senator High School. It was a coach from Senator High School. You're dealing totally. When was the last minute that thought to put? When at the last minute that thought to put Karmelo Anthony, he had less than 10 minutes to prepare. Yep. Let's see here. The judge still had transcripts that haven't been completed and required it. Yes. I heard about that too. Yes, Crips and Bloods and abortions are part of the genocide plan. The trolls must be nervous about the appeal. They all came in here now. Lord Jesus. That's why he was over there in the first place. Okay, Sister God is on the stand right now. Hey, how you doing, Terry? And he will show his power just like he's been doing for us, the true Jews, the Israelites. Come on the trial of Judah and lead the other 11 tribes back to God. We are on. Yes, there's something spiritually definitely moving. This was a very wise move by the Dream Team because the transcripts are in the judge chamber, and if anything is left out, oh my gosh, yeah. I said that this morning too. This morning. Black Lives Matter got this matter, and White Lives Matter is at the helm. I found that out today. After Judge Roach blocked all media saying no cameras, so he could protect the witness so they could tell the truth. And the 21 witnesses still lied. Okay, I got through that. Now I need to go. Now I've already read Exhibit 5 before y'all got here, before we read Exhibit 10 and then 18. So let me go to, is this 10? Let me go to 5. Let me see what that is. If it's all this 30 paragraphs, I'm not going to read paragraphs that for the top. I wanted to read from the bottom. I wanted to find some reading the bottom and the middle and look at some exhibits. At. This is where the nitty gritty at. This is the devil's in the details. Let's see, and then I'm gonna let y'all go. Justine, 2 hours and 31 minutes is Exhibit 5. Exhibit 5. And I know, trust me, I'm not going to hold you long because I got to go to work. I do enjoy your company. I was about to have a meltdown, but I regained my composure. Okay, here we go. Is this thank you letter? That's Exhibit 6. Let's see what 5 is, since it was brought up. It seemed like somebody had some transcribed some stuff. Is this 4 or 5? Is this 4 or 5? Oh, Exhibit 3. Hey, we need to come out to Exhibit 3 tomorrow. Because this is a transcribed, a televised interview. Oh, nah. Hell no. No. We went over that last night. We're not gonna do that interview stuff no more. John Roach can keep that. His version is number 5. Written statement of John Roach to Okay, yeah. This right here is just John Roach. This is just showing that Judge Roach was not was biased, right? So let's go to 18. Yeah, nah. Okay, let's go to 18. Let's see here. 12, 13. Who are you? 18. Declaration of Thelma Anderson. Oh, this is the young lady that was on Freezy last night. Her name is Thelma Anderson. So, Justine, at 2 hours and 33 minutes, Exhibit 18, Declaration of Thelma Anderson. All right. So, this is Affidavit of Thelma Anderson. Okay, County of Dallas. Before me, I undersigned notice public. On this day, I personally appear, Thelma, Anderson, who being held by me duly sworn, deposed, and stated as follows. Background and personal information. My name is Thelma Anderson. I'm over 18 years old, of a sound mind, and fully competent to make this affidavit. I have personal knowledge of the facts stated within, and they are true and correct. I'm a member of the public. I have no role in the case. I sought to observe the trial proceedings in K-State versus Karmelo Anderson, which were of substantial public interest. Although this trial was technically open to the public, the practical limitation imposed by the court substantially restricted the meaning of public access. Number 3, the statement below are based on my own observations and on emails I sent and received during my efforts to attend the proceedings. Number 4, on June the 1st, 2026, I attended the courtroom for my jury questionnaire proceeding. I understood that the questionnaires would be completed that day and that voir dire would begin later that week. I approached the courtroom coordinator to ask where members of the public would be permitted to observe and whether any accommodations would be available given the significant public interest in this case. The courthouse was closed June the 2nd. Jury selection. So now I know when the jury was selected. The jury selections officially began June the 3rd, one day before the trial. On June the 3rd, the court provided an additional viewing location outside of the courtroom where the members of the public could observe the proceedings. Although court personnel referring to the room by another name, it functioned like what is commonly known as a jury service or holdover room. This arrangement allowed members of the public who could not fit inside the courtroom to observe the proceedings, and reasonable accommodations accommodated the substantial public interest in this case. On June the 4th, 2026, the first day of testimony, the court eliminated that additional viewing space. They took it away and limited public access to approximately 27 seats inside of the courtroom. No overflow room, no alternate viewing area, and no additional accommodations was provided. Public access was therefore limited exclusively to a small number of seats inside the courtroom. Access was determined by pre-dawn line, not the scheduled admission time. Number 8. Although the court order specified a time for public admission, the practical reality was very different. Individuals began arriving at the courthouse during the early morning hour, often between 4 and 5 a.m., to secure a seat, one of the limited seats. The process became comparable to a race for access, with members of the public competing for a very small number of seats. Those who arrived after the unofficial line had formed often had little or no realistic opportunity to gain admission regarding of time stated in the court's order. So this is just proof that Karmelo Anthony was not given that amended 6 right to a public and speedy trial was violated. So that's what this is showing and supporting. In practice, access was determined not by the scheduled admission time, but how many early a person arrived and whether a person was able to secure a favorable place in line. This system effectively excluded many members of the public from observing a trial that had generated substantial public interest. Number 10 and 11, because of these restrictions, I was unable to gain entry into the courtroom on June the 4th, 2024. That was the first day of the trial. If they had been an overflow room, I would have went to the overflow room. On June the 5th, 2026, I again attempted to attend the proceedings, but was unable to gain entry because of the limited seating and admission procedures. Okay, my request for an alternate viewing location was denied. Recognizing the several limitations being imposed, I submitted an application seeking media credentials and also requested that the court provide an alternate viewing location for members of the public. My request was intended to address the obvious oh gosh. Yeah, my brain is fried right now. Problem, and to restore a level of access similar to what had been provided during the jury selection on June the 3rd. Give me a second. In that email, Mr. Stoller explained that the courtroom held only about 70 seats, that the prosecution and defense families each received 15 seats, that the judge allotted only 9 seats for the media, including one for the courtroom sketch artists, and that after court staff, only about 24 seats remained in the general public. There was no overflow room. A true copy of that email, which I received, okay, is Exhibit A. Conditions I observed. During the times I was present in and around the courthouse, I did not observe any disturbing security incidents or disruptive conduct by members of the public that would explain or justify excluding the public from the proceedings. That was very good to put in there. Summary, number 25. While the courtroom may not have been technically open to the public, meaningful public access with severely restricted in practice. Access depended upon arriving before dawn and during hours of waiting, navigating an informal and often changing line process, and competing for a very limited number of seats. The court's decision to continue the overflow viewing room that had been used during jury selection further exacerbated these problems and requested for reasonable accommodations, and alternative viewing arrangements were denied despite the obvious demand and the court's own prior use of the auxiliary viewing room doing X, Y, and Z. All right, investors. Okay, I'm gonna read the comments and then I'm gonna give you back your night, my lord. New counsel for Karmelo, please request. Okay. 45006 in Internal Revenue transcripts for all Metcalfs. GoFundMe accounts. Come on with it. She was great. Karmelo Anthony relatives affidavit stated that 15 seats. Okay, yep. We're diminished to. Okay, I just read that. Karmelo had aunts, uncles, grandparents that traveled a long way distance to find. Wow. I did hear about violence in the Anthony home on Freezy podcast with former prosecutor defense lawyer Tony. You have seen her on the other podcast covering the Anthony case and possible advisor to the. Was she the public opinion? Was this Thelma Anderson? All teenage witness testimonies tossed out based on their contradictions at right and the facts. Right. Thank you, Tony, for educating the public about this. I'm gonna go drink some water. When the transcripts from IRS are viewed, we can see who is connected to the. I got you. But that information may be considered confidential. But now, if it's an exhibit in the court proceedings, we may be able to see that. Facts. We still asking that question. Let me see here. Let me do a quick search on knife. And if I find any entries of knife, my throat is about to close up. We'll bring it back tomorrow. As of now, it's only 3 inches of knife. So I'll go ahead and show this. Justine, 2 hours and 43 minutes. Just put, the poker. It's only 3 inches regarding knives. And this is have y'all see? Do y'all see it? Yeah, here we go. Now, bearing in mind the foregoing instructions, if you find from the evidence beyond a reasonable doubt that on about April 2nd, 2025, in Collins County, Texas, the defendant Karmelo Sincere Anthony did intentionally or knowingly cause of death of an individual namely Austin Metcalf with a knife, a deadly weapon, or with intentions to cause serious bodily harm to Austin, and an individual did commit an act clearly dangerous to human life by stabbing him with a knife, a deadly weapon that caused the death, then you will find the defendant committed. Okay, so this is the instructions. Okay, so let me read this again. Now, bearing in mind the foregoing instructions, if you find from the evidence beyond a reasonable doubt, even though we have read that the knife would not be brought into trial because of the evidence. The agreement, right? That on or about April 2nd, 2025, in Collins County, Texas, the defendant Karmelo Sincere Anthony did intentionally unknowingly cause the death. Now, these are the instructions. Cause the death of an individual named Austin Metcalf by stabbing with a knife, deadly weapon, or intended to cause bodily serious injury to Austin Metcalf. An individual did commit an act clearly dangerous to human life by stabbing Austin with a knife, deadly weapon, the cause of death of, then you will find the defendant committed murder as charged in this indictment. If you do not so believe, or if you have a reasonable doubt, therefore you will next consider whether he committed the lesser included offense of manslaughter. So it was instructions of manslaughter. But the jury basically said off these instructions here, that's why we went over that as a juror. You will be given instructions on what to do. So all 12 of them said that beyond a reasonable doubt, what they saw and what they heard says that he intentionally and knowingly caused death to Austin. Where's the other one for a knife? Knife. The manslaughter. These are the instructions. For it. And that's it. That's the only thing about a knife. So that means now, yeah. So evidence did not support submission of instruction. Even viewing the evidence in light of most favorable to submission of instruction, the record did not permit a rationale founding on the third Smith element. The state may point to the evidence that the defendant remained in the area exchanging words with Austin Metcalf, possessed a knife, and took part of a confrontation. Even credited, such evidence does not show that the defendant acted or spoke with a purpose and intended to provoke Metcalf's attack as a pretext to inflict harm. Provocation requires more than words. To all of the haters in the word, provocation requires more than words, presence, poor judgment, or participation in a confrontation. It requires evidence of a preformed design to create the occasion for a deadly force. For all of the haters in the room that are still here and may find this video, may even get to the end of this video, this is the legal term of provocation. It's not when he said, put your hands on me and find out what happened. You'll find out what happened. Or don't, whatever they tried to make us believe that provocation was, that's not provocation. This is the definition of provocation. Justine, 2 hours and 47 minutes is the definition of provocation. This is the exact definition of provocation. Provocation requires more than words, presence, poor judgment, or participation in a confrontation. It requires evidence. It requires evidence of a preformed design to create occasion for deadly force. Amen. Amen. And that's on page 56 of 63. I think that was it for the knife. Knife 3, 4, 5, 4, 5. We read over 1. Okay, this is 2. Where's 1? Okay, here you go. Where's 1? Oh, this was the 12. This was the 112 that I read. And this is where we had to go into Exhibit 10 because I wanted to see what was said about the knife. Which Exhibit 10 was Mike Howard's affidavit and basically said that it would not be admitted in court. So let me go into the comments and then I'm gonna go. Yes, great word. Thank you. Thank you so much. Thank you so much, sweeties. You're a great advocate. We need to talk behind the scenes. Oh, also, if you're a member of this channel, I'm going to have a members only tomorrow or this weekend. So please stay tuned. Turn on your notifications because we're going to talk behind the scenes. Okay. Great work. Thank you so much. Thank you so much, sweetie. Statements given to the office can and will be used once they got on the stand. They were charged with the statements, facts, perjury. They have to get something bad on Karmelo, and it still not outweighs the. Come on with it. Come on, Karen President. You're right. Outweigh the twins' booty. Come on with it. Come on with it. Attorney, all are allowed to access the. Gotcha. Okay, I see what you're saying. I got what you're saying. What tool did the kids throw? I think it was illegal substance on moving mountains. I think it was legal substance. Does Texas stand your ground law? Trump murder him. KA was 17. We're gonna talk about that. We're gonna talk about that. I'm not believing nothing Mike Howard has to say. There's no way he should have made the agreement wrong. You're right. Unless they had something. The only thing that Mike Howard has not said what they got on him. That's the only thing he has not said. Cover up for Hunter. Violence was due to a mob attacking and vandalizing them. Those jurors should have never been Well, I will know this. In the second trial, the jurors that was part of the first trial would not be part of the second trial. I know that. I looked it up. The Anthony family suffered a lot of violence and they had to move. Yeah. Thank you for keeping Georgia in the loop. Come on with it. UATL. I remember you. What fools hear someone say, put your hands on me and find it? Mad cow. Sylvester. Until next time. Make sure. Oh Lord, I'm exhausted. Sylvester, until next time, make sure you get your notes, your drink, and your vest. And we stay vested up over here at Tony Talks Vested Up, compelling sports edge. Stay vested up. This is proof that Karmelo Anthony was wrongfully convicted, set up, and the fix was in. And really, they care more about an agreement that they had behind the scenes than this young man's life. the appeal and a new trial will be granted. And the Supreme Court and the Department of Justice will soon come knocking on Collins County door. I said this 30 days ago. This right here is just proof. This is proof beyond a reasonable doubt that the federal government will get involved in this case and Collins County's actions. So, Vestas, I see you again. Let me try this again. Until next time, make sure you go in and get your notes, your drink, and your vest, because we stay vested up over here 365 degrees at Tony Talks Vested Up Compelling Sports Edge. I got you, Vestas. I got you. Sleep well, sleep well, sleep well. All right, Vestas. Let me make sure there ain't no more. Thank you so much. Thank you much. She said, go rest your butt. There you go. They didn't want to. Yeah. All right, Vestas. I love you all. Bye, Vestas. The multiple assailant law, that is considered a deadly weapon. So that means that Karmelo Anthony, he meant deadly force with deadly force. If being circled with 4 people, 2 people together was almost 500 pounds, 440. That means he meant deadly force with deadly force. If they could have had their way with Karmelo Anthony, we would be singing a different tune. Definition of defense of property. Since Hunter just said that Austin grabbed his property before the fight took place, that means that those boys was aggressive. This young man is sitting up in the bleachers minding his own business. Let me paint the stage since Mike Howard didn't do it for the jury. He's sitting up there invited under the tent. And Tony Talks Vested Up. How you know they coming with aggression? Because we saw how they was walking up to them stands. And they went up in the stands. And Hunter just told exactly what happened. He said, we walked up to him and told him to move. Aggression. He still didn't do nothing. They tell him to move. All these multiple people, 150, 220, 220, maybe 150, 150. Oh, it's hot. It's hot under that tent. You don't know what's going on. The original people that saw the video, it said it happened in a matter of seconds. Fast, sufficient evidence. The prosecutor has a burden of proving every element of the defense beyond reasonable doubt. If it cannot do so, the defendant is entitled to an acquittal. The prosecution has the burden of proving every element of offense beyond a reasonable doubt. If you can't do so, it said every element, the defendant is entitled to an acquittal. What did Hunter say? Then Hunter say, we went up to him. Oh, Hunter. Oh, Mike Howard. Oh, prosecutor Greg Willis. Oh, Judge Roach. Oh, Texas AG Ken Paxton. Multiple assailants. That they don't think that he should have took those measures to protect his life with the weight of a middle schooler. So for everybody that's painting that Karmelo Anthony reached around in his bag and got the weapon, tell Hunter that, because Hunter just said that Austin took his bag. They want us to believe that Karmelo Anthony threw away his future for Austin Madcalf. With this 3.7 GPA, graduating the next month, no disciplinary action, captain of the football, captain of the track, and 21 scholarships. Get out of here.